Yes.
I think you'll also, my lord, they allow me to go to an application of the other settlement matter tomorrow morning.
What is this?
Or even today morning too,
Okay, we'll see.
my lord.
We'll see. Let it be. We'll see.
Maybe. But bring motion matter tomorrow. And also for IA tomorrow. One of the infrastructure application procedures which to allow the earlier day when to Mr. A.B. Chaudhary, finally justice A.B. Chaudhary, because he had received the matter and particularly restored in some benefits. Another IA filing.
Yeah, dismiss the matter.
No. Yes. That was restored. Again, an order by the railways was stayed by my Lord Justice Chaudhary. But subsequently, what happened? Like two writ petitioners had filed the applications. Two could not. They're out of station. Those two have come back again. So we are seeking an endeavor of that to be done.
Let it be listed before
My lordship.
AG Chaudhary.
And one before my lord tomorrow.
Both.
Okay.
Both.
The one better for tomorrow. Okay. Lordship, I'd like to mention executions taking long after vacation the last week of October. Any whether lifting of a petitioner's water supply is disconnected.
Huh?
Petitioner's water supply and extent to device.
Who is for the water? Who is water resource department?
GMD.
GMD. Who's for the GMD?
So as for a
You please tell him to train instructions in the meantime.
But by extension, this thing on item for tomorrow. Motion, my lord, is it termination of a dealership of petrol or petrol fuel.
Okay, let it go to the other thing.
the one and the other lot. I think now 49 lot. 1 minute. But can it say 2 lot? Yes.
Item?
49. 1 minute.
Okay.
Wait, I think item number 35 of the
Yes.
this method of becoming
Okay, Mr. Mr. K. Bora, learned counsel for the
MK Bora.
MK Bora, learned counsel for the petition submit that the writ petition has become instructed. Accordingly, the writ petition dismissed as instructed.
Interim order was there.
Huh?
Interim order was
The interim order stands became.
Yes, Teja, that's it. Listing of the restriction for motors tomorrow, your lordship,
Okay.
of like,
by Bexbook, for calling of records, pertaining to item 50. Additional affidavit has been filed. Another for disclosure.
This is a new case.
Yes, your lord.
How many matters? After vacation.
five.
Wait, please, your lordship, for this thing of motion maps tomorrow.
Deeply obliged.
Happy, your lordship. My lord, I beg question item 29.
Look, all motion matters for tomorrow, give it to him.
My lord, item 29, this petition has become infructuous.
Item,
29,
Mr.
and
Mr. N. Anand, learned counsel for the petitioner, submit that the writ petition has become instructive.
And
According, huh?
and for the missing of
Mr. D. Gogoi appears for the MAC. I am missing autonomous counsel. The writ petition is accordingly dismissed accordingly dismissed as instructed.
Lordship, the petition for item number 88, that
Yes.
become instruct.
What is your name, madam?
M. Lady, Lordship.
Huh?
M. Lady.
Miss N. Devi. Here for the
Petition
Miss N. Devi. Item is item?
80, Lordship. 1 8.
Okay.
7.
What about 18?
29 for the petitioner, my lord, it is also been instructed.
Okay, Mr. R.M. Dekar, learned counsel for the petitioner in WPC 6967/2020, and Ms. N. Devi for the petitioner in WPC 7881 of 2018, submit that the writ petitions have become instructed. Accordingly, the writ petitions have been instructed.
My lord, in respect to item number 28,
Yes.
we have filed an affidavit in opposition, my lord, on for it may kindly call for a record.
You have respondent number 6.
Number 6. Reply of right.
It's not in the record.
Yes, my lord. Paying for call.
Huh?
for listing of the petition immediately after the petition.
Okay.
That is the law. Also, the consider other than like to mention maximum of 15 hours, 1 5.
Yes,
In this case, we're supposed to file affidavit.
15,
50.
15 years.
We've taken consent and order. We need some time to more time to file it. So 19 matter, so we have taken
Mr.
it.
Counsel, yeah, 5 years have passed.
Just third time the matter is in this law. That will ask.
Whatever it is, you're withholding the security deposit. He has completed all the work.
In fact, the petition is even out of state. And here's the question.
Petitioner out of station is not the issue. The issue is the grievance of the petitioner, which is pending before this court. Why are you,
After the petition.
huh?
Immediately after the petition.
Why are you withholding? 5 years have passed.
Even
You give him back the money.
defaulter law.
Huh?
Yes, he is a defaulter. That
He's a
means-
defaulter.
Yeah.
Okay, right. Where is the petitioner?
He has it.
Where is he?
He's out of state because personally I contact.
Item
Item 15.
15. Okay, right.
Right.
Mr. R.R. Gogoi, Land Counsel for the Forest Department, praised for last time
Yes, sir.
to obtain instructions and file affidavit. Inasmuch as the petitioner's prayer is for release of the security deposit. To some. The case has been pending for the last 5 years, and accordingly, last chance is given to the respondent to file the affidavit. This is the matter. After the, after the,
Public.
So watch for that section I speak about.
yes,
Lordship matter but and fact.
appears so. Right. What is your name, madam?
F and Jamal.
F?
F and Jamal.
Senate counsel appearing on behalf of,
Petitioner Lordship.
F and, petitioner submits that the matter pertains to bench file. Registry to verify and is the matter before the appropriate bench.
Procedural lordship. Also, put a consent from the other side. I take it on item number 26.
26 years,
Sir, lordship, we are filing the affidavit in opposition during the course of the case.
26 pertains to, okay, no affidavit in position. You're going to file it
We are
today.
filing on today.
Okay, right. What is your name?
KK Methi, I am appearing on behalf of Mr. SK Methi.
Mr. K.K. Mehdi appearing on behalf of Mr. S.K. Mehdi, CGC, submits that affidavit in position is going to be filed on behalf of the respondent during the course of the day. Who is for the petitioner?
Mr. M. Sir, consent has been.
You're for the petitioner. So, have you been given a copy of the affidavit? How are you going to file it?
On today, we are filing for copy for
You please furnish.
Yes.
Mr.
take shot on.
A. Ghoshal on behalf of
M.
M. Biswas, Learned Counsel for the petitioner is granted liberty to file affidavit in reply in the meantime. This is the matter after the wiki.
I beg my
32. Infractors. Location of IMFL wine shop. Okay, right. Miss, your name, madam? C. Sharma appearing on behalf of P. Mahanta, Learned Counsel for the petitioner. Submits that the writ petition has become infracted. Accordingly, the writ petition is dismissed as infracted. Yes, next.
Bracket 22 and 23, or 23 and 24.
23 infractors.
No, it is regarding freedom market of period is over, but I got some claiming the.
Mr. Counsel, let's give me that. 23, 24. Let us see your prayer.
I'm not free much time.
I have got the file. What do you want now?
I not there. But only there is a case regarding.
If that is the case, if that is not a prayer,
Permission with them.
and if that is not an issue here, why should we keep it pending?
Now, there is a, they are not filing every field, and second case, there is a issue, but there is no payment of minute my monthly.
Huh?
60.
Huh?
Installment is to pay in second case. But
What?
there is two cases, not.
I know. So tell me the first case, what do you want?
So you like, and after time,
Let it come up. And you later, you make the submissions then. Fine. Yes. Huh?
That is 20.
by taking possession of the opposite party minor, I have experienced an item number from
Item number
19 to 20.
19 to 22.
Here in this method, we are newly engaged with some time to get the free base. Earlier, this method was taken up by justice,
Right?
and we are newly engaged.
Yeah, for whom? Appearing for whom? Petitioner. Liquidation.
We are from the side of things. So,
Yeah, for the petitioner. Who is he for?
basically,
What is this matter about?
is there of the
Huh?
release of justice.
Release of? So this company has been liquidated? Yeah, I've got no clue.
Sir, it is about
Liquidation. Correct?
what illegal border outpost in
So, what about it?
so they are not releasing the NCO. Liquidation.
Who is not releasing? The respondent. You are paying for whom? Respondent numbers? Mr. Counsel, there are 6 respondents. Huh? Well, who's the senior? Who's the senior?
AI,
Where is he?
next another one.
Thank you. Now, why do you want to adjourn the matter?
But we are newly engaged.
When were you engaged? Have you submitted Bakalatama? No. When are you submitting?
But even I'm with the party.
Okay, right. What is your name?
It's good.
Huh?
It's good.
H. Kuli. How do you spell? Kuli. KU. Submit that. Your senior, Mr. A.I. Ali. His name is already here in the call list. That means Bakalatama has been submitted.
Earlier, he was a part of the council. But since the honorable justice gave him a permission. And the party has taken back the brief. The party has taken back the brief. Again, the party now again re-engaged with the AI method.
So what is it? It's the same old thing.
We are still to receive the brief. Yet to
If your client doesn't want to give you the brief, he doesn't want to engage you. You tell him to give the brief to you. Otherwise, we'll dispose it off on the next. With or without. State fully learns also for the petitioner. Submits that that he and his senior Mr. A.I. Ali have been recently re-engaged by the respondent number 1 to 5. And however, they have not been given the brief. This matter after the vacation to enable the respondents number 1 to 5 to obtain the brief and make submission.
Please, Lord, I beg for listening the matter, Lord, for tomorrow. Don't
New matter, old matter, what is it?
new matter, Lordship Moksha.
Okay,
Don't
okay.
prepare our Bhima order.
Non?
Don't prepare Bhima order.
Non? What?
Prepare Bhima order.
Non what? Non what?
Compliant,
Non-compliance with the Zima order. Zima order passed by which court?
CGM Qatar, Lord.
But it's a contempt.
No, Lord. For listing, Lord.
If I give it to the registry,
Protect, Lord.
it is your lordship. By the last order,
Those two were order dated 27/9/2024. There is a direction of the honorable court for the personal appearance of the principal
Yes,
secretary.
yes.
He is present for.
Yes.
So Lordship was basically asking us why there is a delay of 3 years in
Yes.
spite of that order. So far as that part is concerned, Lordship is that. So I seek unconstitutional apology, but there are certain circumstances which I'd like to apply this on. So far as this order is concerned now, Lordship will just 4 weeks time will comply. There is no difficulty on that. So there is a direction to verify it and finally dispose of if there is payable to them. That we are going to do it. And initially for first year, he was not in service also. So he has come back and joined. So he has given the undertaking that in 4 weeks time, he will comply. But the overall situation is Lordship in 2021. This order was passed, and there are other lot of cases, about more than 400 to 300 cases, where there were directions to pay the amount after verification. And one such case came before this honorable court. This honorable court was placed to dispose it of in the month of August. In that case, the first order was passed by another court, a coordinated bench. That background will clarify the actual situation. By my Lord Justice S.K. Mehdi, the interim order was passed on 27/5/2022. So in this case, Lordship, there was a claim for about 31 crores 50 lakh for supply of mosquito nets. Then the Honorable Court observed that this amount cannot be distributed. Paragraph 4.
Yes.
R.K. Musahari Learned Standing Council has placed before this court an order of 15/11/2021, whereby to deal with matters of non-payment of bills to the contractors or work done supply. A committee has been formed in terms of the full bench in Tamsil. Though there is an easy court for this court to refer the matter to the committee, the amount involved in this case raises grave doubt and suspicion, more so when the amount involved is public money paid by the taxpayer. It is not at all fathomable to accept that supply of mosquito nets in 3 blocks, the grave price will be 31 crores 50 lakhs. In view of the matter, this court has requested the learned at AG Assam. The AG had submitted that the issue involved a serious one which requires some enquiry by the competent. This court is also of the opinion that public money cannot be allowed to be siphoned off in the manner which the prima facie appears to be facts and circumstances of the case. In that view of the matter, led a committee constituted by 3 competent officials of the Department of Home, Finance and WPC and PC Department, along with involvement of the Principal Secretary DPC. At this stage, so-and-so has suggested that the committee can be constituted with the following manner: Principal Secretary, Finance Department Chairman, Principal Secretary, PTR, Member Secretary, Commissioner Secretary, Home and Political, so-and-so and BTC Department Member. The committee constituted shall examine the aspect of this matter and submit the report after taking into consideration all the relevant materials, including recording of statement. It is made clear that the functions and jurisdiction of the aforesaid committee would not be restricted to the present case, but would look into all other cases where the demand for paying so-called pending bills for work done supplies made in the BTC is 10 lakhs and above. To facilitate the committee to make the inquiry, the authorities of the BTC, namely Principal Secretary, shall direct that all such claims of 10 crores, 10 lakhs or more be routed through the committee and consequential steps be taken only after receipt of the report. So this order was passed out. This encompassing all the cases. Huge cases were coming up. Therefore, the writ petitioner went to the division bench. Division bench first order. Lordship will kindly see the order dated 15/6/2022 in the division bench. The last page. In the meantime, the operation of the impugned judgment and order dated 17/5/2022 passed in shall remain stayed. So the committee's working was stayed by this, and subsequently the order dated 17/11/2022. Lordship will kindly come to the third page, internal page, without expressing against the interim order, the division bench took up the matter. Without expressing any opinion on merit, we deemed it fit to dispose of this appeal with a request to the learned single judge to give priority to the matter and dispose of the jurisdiction without in any manner being influenced by the observations made in the impugned order as well as by this order. Till then, the order dated 15/6/2022 shall continue. It is, however, further clarified that this court has not expressed any opinion on the main issue involved in the decision. The learned single judge shall decide the case issue independently. So thereafter, the interim order was in force till the order was disposed of. That decision was disposed of by this honorable court on very recently, Lordship. 2nd of August, 2/8/2024. In that case, that case of Munoranjan Brahma. Lordship will kindly come to paragraph 15. Accordingly, in view of the stand taken by the state respondents and the claims of the petitioner for payment of outstanding duties being examined for supply of 4,50,000 mosquito nets, which have been distributed to the identified BPL families under the WPT and PT for the year 2017-18 in terms of the full bench judgment considered. This court directs that the examination being done by the state respondents should be concluded and payment made by the admitted amount within a period of 4 months from the date of receipt of a certified copy of this order. So our understanding is that Lordship has revived that committee. Now the committee can look into it. Although the other part of the law is that the interim order merges with the final order. But Lordship has very clearly said otherwise we'll have to come for a clarification whether the same committee will work or the state respondent. This court directs that the examination being done, so it is being done by the state respondents and should be concluded and payment made for the admitted amount within a period of 4 months. In any case, we are going to do it, Lordship. Maybe we'll seek a clarification or we'll apply our mind, Lordship, and we'll take a call on it. That's why 4 weeks time will be sufficient for us to complete this exercise also. In the meantime, Lordship, I would like to give it later, which I have received in affidavit will file it. What happened from 2010 to 2020? There were large number of work orders regarding construction and regarding supply. So the BTC authority, there is a change of regime in 2020 later part. So as the budget was very limited, and when this huge for 3,000 crores demand came up for the new regime law in 2020 later part, they engaged their authority agency to verify all the work orders and found that out of 3,000, only 1,100 were genuine. Rest all are fake and dubious documents. That is one part. Recently, last month, Lordship, the executive committee of the BTC has also taken a note that we have to go for a full-length inquiry. In any case, Lordship, this order I am not saying, but general perspective I am placing before this honorable. So that being the situation, Lordship, we'll definitely verify within 4 weeks. Lordship will kindly give us 4 weeks time. We'll come with a status report about the inquiry in respect of this. But this is the current position. There is no such work for 3,000 crores. 3 blocks, 31 crore mosquito net. It is unimaginable. That is a situation which was going on in BTC from 2000 to 2020. But we should honor the honorable court that if we have to come with the correct facts. Now, in this case, there is a demand for 6 crores plus 4 crores for supply of inputs. It is also unfathomable. That's what I'm using from Milo Justice made his judgment. So we'll verify it, Lordship. That is why that committee which I have suggested, Lordship, the honorable court, the principals or commissioner secretary of the Home Department of, if there is any fraud, immediately the police action should follow. If they are genuine, the payment should be made. So we are going to do it, Lordship. Either way, it will happen.
But you see, that is the thing.
It was not placed before this honor.
The thing is that when this court has directed that a verification should be made
Absolutely.
within a time frame,
Absolutely.
we should do the verification.
Exactly, Lord.
Now, first of all,
Had
the
it been a
verification
single
not done.
standalone case, Lordship, that would have definitely been done. But there were more than 300 cases of identical nature. Every day the cases are being listed, but we have to take a and straight call now.
No, but then another thing is that, Lord, you all are not making any submissions to that effect during the
That is why,
proceeding.
because our officers also are giving us confusing instructions. I refrain from appearing into some of the cases. Some of the officers are hand in glove with the contractor. That is the problem. That is why I suggested the principal finance secretary from the state government, home secretary from the state government, the PTC's principal secretary should be there as a member. Our officers are themselves involved. And everything will come into light now. The Lordship will kindly give us 4 weeks time. He will get ample opportunity to defend his case before the committee. Because the direction was for verification. We'll verify it. We'll follow all the principles of natural justice. If he cooperates, then Lordship in 4 weeks time will place the report.
Already they have filed in the affidavit, admitted them on lordship.
Yes, that is the problem.
They're not denied lordship. They
We'll
admitted them.
take him now to the places where he
Lordship.
supplied those tin sheets now.
Number one lordship. Number two lordship, they undertake this court lordship on 15 November 2021 lordship. They will complete the verification within 6 months. This is their commitment lordship. This is their speaking order, not today's order lordship. Thereafter lordship, and as per order dated 16 July 2022 lordship, they disbursed for about 86 crores lordship. Without lordship verified. How they disbursed this fine lordship? So on record, there are about 1700 contractors, among contractors, they disbursed the money lordship. Among them, 700 contractors, there are some few contractors also, it's my client lordship. They received some amount. Already I'm in cases, I also like that.
Where is the admission made by them?
Yes, lordship. Kindly come to the number lordship. 16 lordship. There are 7 and 8 lordship in my contempt in the affidavit. For contempt, I have connected. Page number
Page-
16, page number, there are 7 lordship. In contempt case, I have connected this affidavit lordship. May I read lordship?
Yes.
That as regard to the constable made in this paragraph 16 and 17 of the writ petition, the answering deponent make state that the statement are textually correct. The answering further state that respondent having received the materials as per the supply order from the writ petitioner, the process for release of payment of writ petitioner is under process. This lordship is the
That is why, Lord. In the writ-
No,
order,
the problem is, now
what I am seeking, suppose it is being verified. We'll close the verification in 4 weeks time and we'll place it before it.
no,
What I am seeking today, I'm not giving any opinion from our side, whether he is genuinely receivable or not. What we are saying that we'll comply with the direction. The direction is that having heard the learned counsel in that if lordship is pleased against which the contempt case was initiated, that order of 24/11/2021, page 36, paragraph 4. Here also the PTC admitted. The PTC has filed an affidavit, have lordship got it. Paragraph 4.
Yes.
The PTC has filed an affidavit in opposition. The PTC does not deny the claims made by the petitioner and has relied on the communication dated 26/2/2021, seeking funds from the Secretary Forest PTC in order to make payments to the petitioner in respect of the supply. Having heard the learned counsels for the parties and upon perusal of the pleadings on record, this petition is disposed of with a direction to all the respondents, including the respondent number 2, is here, to make necessary enquiries and verifications into the claims made by the petitioner and stated to be admitted by the BTC. So this honorable court also did not believe the BTC authority. In spite of that, direction was given for verification. Upon such verification and enquiry, if the claim made by the petitioners are found to be correct and payable, then the same could be released. That's why I'm seeking unconditional apology for the delay. But we are going to do it in 4 weeks.
so you mean no inquiry has been made?
No inquiry.
Then how come your office,
Inquiry in general was made individually.
but how come,
Now the principal secretary is before this honorable court. He will verify it.
no, but one thing, you see, the problem is when your officers make a affidavit to the court.
That is why lordship, my
to do?
submission is that I have with full respect, I am
You should take action against those officers then.
absolutely, lords. That is why about a month ago, the whole commission, the executive council of BTC, with the chief executive member, they have decided to go for a full length inquiry.
Anyway, let them take.
This letter which I have placed, Lordship, 3,000 crores claims are pending with us. And when we verified, only 1,100 crores are found to be genuine. So we have to file FIRs also now. The criminal proceedings will have to, and whoever heads is to be turned, it has to be turned. Public money cannot go in that way.
How the disbursed is 9 crore.
Okay, no. The thing is this, when the court has given directions that there should be a verification,
We'll do
3
it.
years is too much. Court gave you, I think, 4 months. Now that we are waiting for
I
3.
say that is why unconditional
Yeah.
apology, Lordship. But the thing is that 3 months, 2 months have elapsed long time back, 2021 itself.
Whatever it is, Mr. Secretary, I hope within the 4 weeks time you will complete the inquiry. With yes. Court has given a direction that it should be done within a specified time period. Now, even after 3 years, nothing has been. So this is not the way.
Lordship, generally it was done. In that letter, if Lordship is pleased to look at that letter which I have done, when if I will file. Third paragraph.
Yes.
It is pertinent to mention herein that the erstwhile BTAT created a huge outstanding liabilities, which is amounting to 3,000 crores approximately during their tenure in the BTC incurred from the construction work issued by them in between 2010 to 2000 February 2020. The construction works were issued by the BTAT authority flouting the budget provisions earmarked in the AOP and SOPD for the financial year 2010 to February 20. The aforesaid liabilities were created exceeding the so-and-so fund allotted to the BTC. It is therefore crystal clear that the amount involved therein raises grave doubt and suspicion, more so when the amount involved is public money paid to the taxpayer. This amount, next paragraph, the present BTC, when audited the aforesaid outstanding levy to an agency, we have done the inquiry of 3,000 crores, it is found that the construction work orders equivalent to 1,000 crores are found to be genuine and raised 2,000 crores approximately work orders are found to be either fake or non-fake. His case may also fall in either of these categories.
Eh? So you complete the,
Yes,
we give you the 4 weeks time, you complete. Because it's not
We'll do
done.
it, Lordship, it is in top priority now. Otherwise, BTC will have to keep up one district. The amount which is being claimed,
No,
3,000
and
crores.
now you see,
Every year the BTC received only 800 crores. That is the budget. If 3,000 crores has to be shelled out on the basis of paid document, Lordship, the whole BTC's economic condition will come.
now you see now,
And we'll do it, Lord.
no, there is a list, I think, made by the BTC with regard to the unpaid contractual liability. And I think 40 departments have made a list.
Lord.
And in one list, there's the chief discretionary fund. I think the liability is towards 1,988%. Now, this is after inquiry, I believe. If that is the case, if it's true, that's a huge amount. Now, that is only under the chief discretionary fund. Now you have got PHE, water resource. Yeah, I believe there are around 40 departments and they have
Yes.
all made lists. Now, do you mean to say all those persons in the list, they are all genuine?
That is why, Lordship, this High Court constituted committee will look into it, number one. And so far as this case is concerned, Lord, the principal secretary has taken the response,
Correct. Heard Mr. J.U. Ahmed, learn counsel for the petitioner. Mr. J.P. Thacker, learned AG, appears for the respondent and submits.
Respondent.
For number 2,
Lord.
and submit them. The order dated 24/11/2021, passed in WPC 2950/2021. Will be complied with within a period of 4 weeks from today. And the result of the same will be communicated to the court on the next day.
Highly up.
List the matter of November.
Second week.
the personal appearance of, that is point number 2 is discrepancy.
Highly of.
Okay.
May I please, Manoj. In item number 1, your lordship pleases.
Huh?
Can your lordships, am I audible, Manoj?
Yes,
Yeah, Malaj, I have good news, Malaj. The termination has been withdrawn in the sense that I have been given an extension as far as this contract is concerned. So, in view of the letter dated 23/9/2024, which my learned friend will hand over, I will withdraw this petition, Malaj.
item number 1.
One, Malaj, item.
What is your name, mister?
PP Sharma, Malaj, Pragyan Sharma.
Your name is not here.
I won't know, Malaj. It was filed locally, but I had given my appearance also, Malaj, and my name in the.
Your name is there. Okay. Well,
Maybe short
okay,
of
it is here, yes. Huh? Very good.
The last name. After it.
Okay, I've got the wrong list. Okay, sorry. Okay. Okay, right. Mr. P.P. Sharma, the learned counsel for the petitioner submits that he would like to withdraw the present writ petition in pursuant to the letter number HRN/Assam Mala 2.0/2024 dated 23/9/2024 issued by the Executive Engineer PWD Hamren Roads Division.
Whereby the
To the
contract has
effect
been.
that the
Sorry.
termination of the petitioner's contract work has been cancelled and he is allowed to restart the contract work. Who appears? Mr. Mr. P, who appears for the respond number? 1 and 2. Anybody else? No one. Right. In view of the prayer made by, in view of the submission made by Mr. P. Sharma, the writ petition is dismissed as written.
I'm so
The letter
grateful.
dated, before that, right? The letter dated 23/9/2024 issued by the Executive Engineer PWRD Hamren Road Division is made a part of the record and marked as an extra.
I'm so grateful. I'm obliged.
You're okay instructing a doctor.
Huh?
You're okay.
What is the instruction? Approval given?
The resolution is not in proper manner, your lordship. File affidavit regarding this, your lordship.
This doesn't say anything.
The inquiry report is reflect the adoption of resolution has been 2020.
Was not held in a proper manner.
Proper manner, yes.
What is the proper manner, your lordship?
I don't know.
Your lordship,
Huh?
out of 15 members, your lordship, 10 members, there were absent.
Out of 15, 10.
Yes. Quorum fulfilled, your
And
lordship.
we'll file details in the affidavit.
Let them file affidavit to over.
It is
Then
like
my-
issue
my-
very simple, your lordship. 1/58/2024, some resolutions were taken.
I know that,
And that
so they have to take a
Yes,
decision whether to approve or not.
I know in the meantime, notice will be issued, your lordship. There are 2 private respondents.
No, why don't you take a decision? But they've already said that it's not in the proper manner. What do you mean by not in the proper manner? I don't
I
know.
know they are fine in the inquiry report, your lordship.
Huh?
They are fine in the inquiry report, your lordship. The inquiry report hard copy is not with me, your lordship. So, give me some time, I'll file affidavit.
I don't know what type of that instruction is. I have also seen, your lordship, not proper misunderstanding, like this communication gap, like this what your lordship said.
What do you mean by not proper manner? You've got to, you see, you cannot better your own reasoning than what is given in the impugn order.
Let me allow to file it.
Like your lordship. Problem, your lordship. We'll list it on the opening.
In the
Well,
meantime,
it's a-
notice may be,
Huh?
notice may be issued in this time.
Notice will issue, but then, we expect your affidavit on the opening day.
Lot,
Has to be there.
lot.
Right. I have Mr. A. M. Khan, Learned Counsel for the petition, who submits that the Assistant Registrar of Cooperative Society, Marketa, has not given his approval to the resolutions passed by the Board of Directors on 16/8/2020. He submits that the ARCS should either approve the resolution or give reasons for not approving the same. So submit Miss
SP box, corporate.
S.T. Buck, Sheriff of the Corporation Department, has submitted two letters dated 5/9/2024 and 1/10/2024, issued by the Office of the Assistant Registrar of Cooperative Societies, Barpita, and the Office of the Registrar of Cooperative Societies, Tanapara, respectively. A perusal of the same shows that the same shows that no reason has been reflected for not taking a decision with regard to the resolution passed by the Board of Directors on 16/8/2024, except to state that the resolutions were not held, were not made in a proper manner due to misunderstanding and communication gap between the chairman, vice chairman, secretary, and the Board of Directors of the society. Ms. A. Bhak,
SP box.
S.P. Bhak, uh, uh, submit that she would like to file an affidavit with this. Right, if you notice, the turnover in 2 weeks, with S.P. Bhak, accept notice on behalf of
That's what 1, 2, 3, 4.
one,
2, 4.
one, there are 1, 2, 3, 4. Petitioner takes steps for service of notice upon the respondent number 5 to 10 by registered post within 2 days. This is the matter on 25th, by which date the respondent number 1 to 4 should have filed their affidavit.
Right.
The reason we are the order number 5 that it is order number 5 that may be different from the only.
Is there any
I'm
prayer,
saying
is there any interim prayer to that effect?
this is there is also only. Have to record.
No prayer, they have not made any prayer.
Okay, sir.
Fellowship, election 30 is okay for that.
Your application to shift has been rejected.
So there might be complaints.
Okay, Mr. R. Kukan, Learned Counsel for the petitioner, submits that the petitioner proposal to shift his IMFL off shop license has been rejected by order dated 2/9/24, issued by the District Commissioner Constitution. To notice, returnable in 4 weeks. Mr. Arab, accept notice on behalf of
Respond number 1, 2, 3, and 5.
1, 2, 3, and 5. What about 4? Mr. G. Bopalian, accept notice on the responsible. This is the the respondent shall obtain instruction and file affidavit by the next. This is the matter after 4.
Public.
Okay. 5.
May I speak to them, sir?
Yes,
So it's the Bina I get from the next time.
yes. Your case is that, your
was
earnest
L1.
money,
I was L1.
your L1, but it was rejected.
when rejected. 2024, when I submitted an RTA application to the authority, know the reason of rejection. Then in the year 2024, they have provided the reason, but without stating the actual fact file. And
So was it a 2-bit system or a single bit system? Was it a 2-bit system or a single bit system?
Bit.
2-bit system.
technical bit.
So your financial bit was opened also.
Yes.
So that means you had crossed the technical bit.
Yes. Then there
So only when was it given to you? Only on
I have submitted RTA application
RTI on
at page 126. On 10/9/2024, they have provided the information.
when did they provide? On
10/9/2024.
10/9/24.
Yes.
That your technical bid was rejected. They
Then
said your bid was
Yes,
rejected.
yes. Page 128 is L1. Xavier Technologies.
No, where have they said that your technical bid
Page
has been rejected?
129, see they are noting statement. Due to some anomaly respect of experience certificate, but I was not given any opportunity to verify for last 3 years. And they verbally assured me that tender will be, work order will be. I have already invested with amount of money. Therefore, since the work has been progressed significant, not proper to challenge the work order.
But then
I should be given the earnest money with interest
when was the work order given to the private respondent?
in 2022.
In 22, when? When in 22?
My lord, as per page 130, we have decided start get on interim accepted and so on.
When? I'm telling the date.
My lord,
I don't want the history.
2/5/20.
2/5/22 work order issued to the private
Yes.
respondent. Private respondent, no, there's no private respondent.
That
To
is
the
private.
to the selected bidder.
Yes.
Now the thing is, why have you waited more than 2 years for return of your earnest money? It appears that you knew that your bid was rejected.
No, my lord, I have submitted earlier my presentation. That year.
Correct. We issue notice on this. Heard, Mr. Yes, Mr.
I'm sorry.
N. Sharma. You're no more with the government.
Okay.
Heard, Mr. N. Sharma, learned counsel for the petitioner who submits that he participated in the tender process dated 12, the tender notice dated 12/7/2021, issued by the GMC for construction of compost and RDF plants of 150 TPD bracket mixed municipal solid waste bracket was at Sonai, Guli, Guwahati, Assam on EPC mode. So the petitioner's bid was L1, the contract was allotted to
Around that.
Huh?
Later,
who was
Okay.
allotted to whom?
page 128, first next year.
Was allotted to was allotted to Geron, GERON, Geron Engineering Private Limited, bracket JV, who was LP. And work order was issued on 2/5/2020. Next up, the petitioner's counsel submits that as the as the petitioner was not being returned his earnest money deposit, he made a RTI application dated
19/8/2020.
19/8/24 for giving reason for not returning his earnest money deposit. Bracket EMD. The state respondent's reply dated 10/9/2024 was to the effect that the petitioner's bid had been rejected. And that the petitioner was not eligible. So and as such, the EMD could not be returned to the petitioner.
That is EMD, there is no mention.
No mention.
No mention. Only why I was rejected, definitely
Okay,
there was some certificate experience.
okay, it was rejected. Tender was rejected as there were some anomalies in the documents submitted by the petitioner.
Experience.
The experience certificate
As part
submitted by the petitioner. Issue notice returnable in 4 weeks. Miss
A portable for
A. Bhattakur accepts notice on behalf of Mr.
P9.
P. Nayak, learned counsel for
All the
all the respondents. This is the matter of the 4 weeks to enable the respondents to obtain instructions. Respondents counsel to obtain instructions and file affidavit if necessary. Yes, what is your name?
Sharma Lordship.
Mr. R. Sharma, learned counsel for the petitioner. Submits that the petitioner's contractual dues amounting to rupees 47,94,335 has not been paid. Issue notice returnable in 4 weeks. Ms. R. DJ accepts notice on behalf of all correspondence numbers 3 to 6. What about 1 and 2? 1 is PWD. Who do we say? Mr. P. Over it. Mr. P. Over accepts notice on behalf of number 1. While Mr. A. Chalia accepts notice on behalf of number 2. This is a matter after 4 weeks to enable the respondent to obtain instructions and file affidavit if necessary. Heard, Mr.
Definitely.
A. Kanikar, counsel for the petitioner who submits that the petitioner's bill for supply of spare parts and repairing of vehicles amounting to rupees 18,15,3 has not been paid. Same thing, huh? Acha. Issue notice returnable in 4 weeks. Mr. G. Bokalia accepts notice on behalf of
1 to 4 and 6.
1 to 4 and 6. Who is 5?
5 is finance.
Mr. A. Chalia accepts. Same thing.
Diplo. Motion to be on the next day for compliance. Keep it up.
Why don't you give it? When can you give it?
That's after the we give it because after two, if the lordship it's on 28th of October, we give it after the because few of the documents they already have, but still we'll give it.
Mr.
Arsha.
Before that, Mr.
Data. It is for the
Mr. Adar appears for the petition. Submit that despite requests to make to the respondent, the required information is not being provided by the Mr. A. Sharma. R. Sharma. Learned counsel for
setting out for respondent 1 to
standing counsel for respondent number 1 to 3. Submit that all the required information will be provided to the petitioner within
by 2 weeks.
within 2 weeks. Within 2 weeks. Accordingly, release this matter first day of opening.
Can it be on 28th or 24th?
When you give me a date, when do you want?
28th, 28th of
Otherwise, why should we keep this pending if they were going to give? We'll direct that you give to them. That's all. What do you want? Okay, right. Mr. R. Sharma submit all the requests. We have said that, no? In view of the submission made by Mr. R. Sharma, standing counsel for the respondents number 1 to 6. The respondents are directed to furnish all the required documents to the petitioner within 2 weeks from today. The petition is accordingly disposed of.
Thank you.
Who's for the railway? Madam, call the railway. Otherwise, having a problem. So this is for the Durga Puja period.
Yes.
Madam, it's just a few days away.
Yeah, that's the particular, the case is something particular like this. And the
Call,
request
call,
is taking
call, call,
chance.
call the railway. The council. After some time.
PWC council notice.
So we wait for him.
Council get instructions.
Mr. Nayak, no?
Yes.
Yes, sir. Okay. And where is the council? I think that council has gone out. There he is.
Next, the case file under 2 big system file, did were submitted. And as per my fee, the bidders has participated in the bid process file. All the bidders were technically qualified file. And subsequently, their price bid has been offered by them. And price bid was the bill of quantity.
Here L1.
I was an L1 bidder. Last time I submitted. Thereafter, subsequently, there after by the analysis of the rate from by the LC bidder, initial LC bidder. Then 3-5 manner. That they said that they on the first day they never said that my bid has been cancelled. Although on that day, my bid has been cancelled, but they are not informed to the court, that our bid has been cancelled.
Bid has been cancelled on what ground?
On ground that form of bid was not filled up as per terms and condition of the contract.
And form of bid, you have to download it
We have to download it and manually we have to fill up
and then
and
upload it again.
and it's an unencrypted document.
Huh?
It is an unencrypted document that is admitted position from their affidavit.
So how does it matter?
Yes, sir. That is the matter, my lord. Because if your lordship submitted a tender, there are other ways, my lord, to submit the bid. That is by the bill of quantities. We have substantially complied all the potential, my lord, in respect of facts and figures in bill of quantities. That document we fill up like that. The bill of quantities which has been mentioned. That is my price bid.
No, bill of quantities is bill of quantities encrypted or not?
And
Bill of quantities is encrypted.
encrypted.
Bill of quantities is encrypted only a financial bid.
Yes, ma'am.
That is not encrypted.
Financial bid so far is the bill of quantities that is encrypted.
Because you see the total bill that comes out of your the bill of quantity will be the same as your financial bid,
Yes.
but they want a separate quotation of your financial bid
Yes, ma'am.
in the form of bid,
Yes, ma'am.
in the form of bid which you have not submitted.
I have submitted form of bid. I stated in my tender that I have a quoted bill of quantities. That is my price bid back. I am stating like that.
Or you have not stated the amount.
Because it is an unencrypted document. They have admitted. Suppose we have submitted the bid price in that particular document. Then there is a specific condition of the contract condition that they can withdraw the bid. Any bidder who has submitted the bid, withdraw the bid, and subsequently they again put their submission bid.
So they can change their bid amount.
Yes, my lord. And
So can they withdraw their bill of quantities also?
yes,
Everything.
everything, my lord. And my lord, main thing is that my lord, there's a condition of 13.1, my lord. 13.1 has said if there is a my lord, difference between my lord two documents, my lord, bill of quantities and form of bid. So bill of quantity will prevail.
Then 13.1.
13.1. That is why my lord initiated that 13% has been done.
Huh?
That is why the initial thinking order has been taken by the 13.1. Your lordship kindly directly come to 13.1. That is 55.
Yes.
That is, the quote shall be for the whole work as described in subclause 1.1 based on price bill of quantity submitted by the bidder. Whole by price bid will be decided on the price given on bill of quantity. That is the condition of the contract. And important thing is that, my lord, they have given rebate to the other bidder which was not given to me.
Yes.
Yes, my lord. But your lordship kindly go to the form of bid of my document. Page 130.
Yes.
Para 1, I have stated we work described above brevety defect on conformity of the condition, specification drawing bill of quantity for the sum quoted as in the price. Next, your lordship come to next para 6. That is important, man. That was not filled up by the respondent number 10. We appoint any person to be appointed to the building Assam as the dispute review expert. Secondly, your lordship, I will put the signature. Address has been given. We will also put the signature. Address has been given, and we put the digital signature right column, right side. Okay. Bottom of the right side. The digital signature with certificate. Now your lordship come to the document submitted by the respondent number 10. Form of bid is 144.
Respond number 10.
Respondent number 10. One they have stated the price 10 for something, 10 for something, my lord.
10 for 50 lakh.
Yes, my lord.
50,000.
Yes, my lord. If your lordship go to the rack put it in the BL of quantity, lordship will find the rack 146 also, my lord. That is last part, my lord.
Yes.
Total in figures. 13 crore 287,265.
So they will go by 13 crore
They will go by the 13 crore.
as per 13.1.
13.1, my lord. And by this way, my lord, they now said that he was the alone bidder because in bill of form of bid, he has quoted 10 crore. Directly violated 13.1 of the condition of the contract.
And L3.
L3 by.
And L3 has been given the contract.
At this time, not given, my lord,
Not
because no work order. Now we will also only one important point, 144. If you also go through the document, my lord, The witness part is blank. One witness is necessary, witness and address, that part is blank. At the bottom line. Okay. There is no address to. But no digital signature, which is mandatory. Court not fill up column of review expert. Keep up blank. The logic can look para 6. That part has been blank.
Yeah.
So I want to say, your lordship, that it is an incomplete document, and this document is violation of the terms and conditions of the contract. Despite of that, my lord, that document has been accepted. If that event has been given to the other bidder, why not the exceptional was not given? And this is a redundant document, my lord. Because if 13.1 has categorically said that if any dispute, deal of country prevail. Then, your lordship, and my humble submission is that in respect of form of it, I substantially complied of that document. My humble, your lordship, come to the page 31. That is important.
Yes.
Yes, sir. Your lordship, kindly read that additional note to clause 12. Mode of it previous document comprising of the bid. Online financial bid shall not be submitted on paper. Bid is not submitted form of bid by the paper form. Even if it is submitted paper form, the party considered the evaluation committee. Additional note to clause 18B, that is important matter. Format and signing of the bid. Here, they have not that signing of this particular bid file. Because there is a condition I will come later on. If any signature put, that should be put to digital signature also. Then an online fill up by the bidder will be has digitally signed as per procedure described in the user guideline. Then you also kindly come to user guideline page 42, my lord. Next page, man. 19.5.
Yes.
The bidder shall generate it following the procedure online bid declaration and digitally signed with his own digital certificate. Submit the hash online bidding procedure for financial bid. The bidder shall, that is very much important, decrypt the bid, submit it and keep the form as per online bidding procedure. But in respect of form of bid, let them satisfy your lordship that can be encrypted. They have done affidavit, they said it is an unencrypted document. They have categorically listed in para 162 of the affidavit, page 162 of the affidavit. Next, your lordship come. Additional note 20, last part, man.
Wait,
Online,
wait.
that same day.
Huh? Yes.
Online bidder must decrypt, submit re-encrypted bid before the expiry of the tender and schedule of the IPA. Failure to submit re-encrypted bid to result in the bid is a cancel bid. Meaning thereby, the form of bid which can be, my lord, not encrypted, my lord, the bid tender of the bid, form of bid, my lord, the tender is liable to be rejected. So, my lord, this tender is liable to be rejected. Because form of bid is, my lord, cannot be, my lord, unencrypted. This is the condition of the contract.
No, just come once again.
Again, fine. Online bidder must decrypt. I don't know what
Online bidder, where do you get online bidder?
page 42.
Yes. The bidder shall fill up all online forms following the procedure for each event.
Yes, sir.
The bidder shall generate the bid hash. What is this hash, bid hash?
Be as kneeling thereby there. So lots of people go to the manner, they fill up the tender document, my lord. That the document is automatically generated. One after another, the document one after another, that is automatically generated. And we are going to fill up the document. Until and unless we not fill up, we are not going to the next page. In respect of my lord, form of bill of quantity. That document is automatically generated. Thereafter, we put our bid value and other analysis value my lord, as per document mentioned. And thereafter, again, this document was re-encrypted. Here in the instant case, my lord, there will also come to the 19.9 last part.
19.8, yes.
Online bidder must decree submit their re-encrypted bid before the expiry date of the tender. Time scheduled in IFP. Failure to submit re-encrypted bid will result being treated as cancelled bid. Let them show, my lord, that form of bid can be encrypted. So here bid is liable to be rejected. That is the my lord.
Where is the rejection of your bid?
Yes, sir. That has been mentioned in the my lord. Affidavit.
Page,
Page 169. Minute of the financial bid evaluation. My humble submission before your lordship is that before going to document it is important. There is an order by
Huh?
Not issued the work order.
Okay.
Yes. Then if your lordship go to this document matter, and when it was communicated,
No, let us see this 159.
minutes of the financial bid evaluation committee, the construction as per minutes of the technical committee meeting date on 2020, specifically the financial bids are open on 2/8/2024 in all the other bidders, other authorized representatives, finance are as follows. Mega electrical quoted bid amount as per CS. Comparative statement, BOQ is 11 crore 89 lakhs 40,000. Quoted amount in form of bid need. How can they say need? I said that bid quoted in my bill of quantity in my price. They have opted. This is my price bid matter. Then next important term. There another bidder, L2 bidder, 11 crore 99 lakh with the Gautam construction. 11 crore 99 lakh, 11 crore 99. And 13 crore 32 lakhs is the bill of quantities of R10 Mela, and his form of bid is 10 crore 50 lakh. Effective price has been taken from form of bid is directly violation of 13.1. They have said that you take the value of this Mela, bill of quantity. But they violated this.
Okay, yes. But if here, I point out clause 13.1 is not say the entire clause. Page 55. It says minus slide. Bid price. Yes. Here, my lord, first of all, I would like to point out that 13.1, 13.2. That bid, the subpara, my lord. Yes. The bidder must quote his bid price in section 6, form of bid, both in figure and word, it to be duly signed by the bid. The next line is important. A financial bid without any mention of bid price, document kindly quoted my notice my bid price. In the form of bid shall be treated as non-responsive and shall not be considered for evil. This is precisely the ground may not why this may not be the thing. This is the only case. This is the only case. My mandatory clause lordship is now trying to the form may not be the bid form of bid submitted by the petitioner. That lordship will find that page 130. Very categorically, there were nowhere mentioned that my lord for non-signing the document, non-giving the witness, or my lord non-giving the my lord
officer or authority will do the arbitration in case of dispute, it will be rejected. If the price sheet will have to be quoted, and this is the price sheet. Page 138. The first paragraph, it says, we offer to execute the work described above and remedy any defect therein conforming with the condition of contract, specifications, drawing, bills of quantities, address for the sum as quoted in the picture. Now, Lord, we will see the other bidders. This is a standard format which was uploaded. From there, they have uploaded. Page 144. Same language.
Yes, I understand what you mean. So basically, you are saying this, the sub-para of 13, sub-clause of clause 13.2. That has no.
13.2, my lord. In fact, in the minute that we have enacted and minute that has not been put to challenge yet. He has only questioned the, my lord, selection of the other side. And my lord, so far as the BOQ is concerned, that lordship may have a look at the affidavit to clarify matters.
BOQ.
Yes.
Where do I get
My
that?
lord, in the affidavit, page serial number 167, running here. Though in the tender document it is not there, but it was there in the portal. And he has downloaded it himself, he has uploaded it. There's no question that it was not there, he is pointing out to a blank page. It was there. Page 167.
Yes.
Lord, you will see, my lord, the payment instruction, cover details of cover number 2.
Payment instruments.
In the middle, my lord.
Yes.
In the right side, my lord.
Yes.
Cover details. Lord, you will see 1 P qualification, technical fee. Then number 2 is finance. That is the finance. Here, Lord, you will see BOQ, PDF. Form of it, PDF. So it was there. It is to be downloaded, and it was to be filled up whatever format page, my lord. That I have just now pointed out. This is exactly the form which was there in the page 138. This was the, my lord, form that will come up. Moment this, my lord, PDF is clicked for the form of it. And for
Yes.
BOQ, the procedure was you will have to fill it online only. You cannot download and thereafter by having it upload. So this was there in the, my lord, technical, in the portal, my lord. He has downloaded, he has filled it up.
Okay,
and with other-
I understand. Basically, your case revolves around
Yeah.
the sub-clause of 13.2.
That is correct.
That's
And that
all?
we have explained.
There's nothing else?
No, my lord, Lordship kindly give it. We have 1 minute. 13.2 he read,
Yeah.
but your Lordship kindly again read. That is why I am submitting, my lord. Rebate has been given to the other context. What rebate, my lord? First of all, he will have to show that, my lord, he qualified. In fact, in the
My lord,
petition, the minute.
Last time I am submitting before your lordship is that matter.
What will see the
No,
clear-
my your lordship. Suppose a person is not qualified bidder, he is metrical. He want to always set the negative equality. Negative equality is not meant that is that a person is metric pass, become professor, my lord, and if a person pass MSc, my lord, after the result has been, after the, my lord, advertisement, my lord, his case will not consider, but you cannot.
Right now, you said that no one has been allotted the work order.
Yes, sir. No one is.
Then-
Yeah, one thing you also get 13 kindly read one.
13.2, yes.
The bidder must quote bid price section sheet form of bid both figure and work, which is duly signed by the bidder. Why he has not it, that's it. Where is duly signed? That is not duly signed. Form of bid document. Again, we will not check any.
No, duly signed by bidder. I'm talking about, no, you're talking about the other person.
Other person, I saw your.
No, I'm not interested in that. I want to know with you.
Yes, sir.
In your case, you see out here 13.2, it says the bidder must quote his bid price
Yes, sir.
both in figure and word,
Comma, thereafter,
which is to be duly signed by the bidder.
Then the
Yes,
next line.
yes.
That is the main.
he has not signed. That,
They finance-
that's
they
not
without-
No, that leave that aside. Why you bothered about him? It is your case right now. You have to qualify.
I want to show one thing, man.
Yes.
148, 146 again.
Yeah.
Where is duly signed document 144? Last part. Cannot sign digital signature document.
No, maybe that we will see. That is, but right now the issue is not about them.
Oh my.
The issue is about you.
It's a reminder, my humble submission before the respondent authority has given rebate to the one part and not given to the other part in same condition, 13.2. That is, my lord,
Rebate, what rebate, what rebate?
rebate has been given because it was duly signed by the department. That has been written down the 13.2. I have categorically read the bidder must quote his price, section 3 figure and what, comma, which is be duly signed by the bidder.
Okay,
Yes, madam. They have considered his form of bid, although it was not put the signature in the
okay, so you are saying that respondent number 10 is also not eligible.
not eligible.
Okay.
Yes, my lord. Respondent number 10 is not eligible. Secondly, they have taken the respondent number 10, where it is categorically terms and condition 13.1 said that bill of quantities will be prevailed in respect of form of bid. Then he is not in my lord.
Then it will be, then there is one valid bidder then.
Yes, my lord, that respondent number is high.
Let me clarify that one.
Yes, my lord.
Notability 13.1.
13.1.
Page 55.
Yes,
It says, my lord, the contract shall be for the whole work as described in subclause 1.1 based on the price bill. Notable kindly notify bill because it is a term contract. Page by page, they will have to keep
That's
the,
bill of quantities.
my lord, they will have to quote the rate of each item.
correct.
At this stage,
Item rate contract.
yeah, that is the bill of quantity. Are submitted by the bidder. Now, Lord will see, my lord, the second paragraph of 13.2. Bidder must quote his bid price. Bid price is in form number 6. That is his bid price. How he will break up, that's a different thing, my lord. Now, my lord, in the affidavit, we have stated, if there is a deviation, my lord, one in my lord, POQ is 13 crore. Here it is 10 crore. Since my lord, 10 crore is the lowest one, it's beneficial for us, we will be accepting that. The petitioner does not accept it, he will be blacklisted. I mean the private respondent.
What is this subclause 1.1?
Yes.
Subclause 1.1, your lordship kindly look. The terms of my lord, contract
Page 47.
is 47.
That is a scope of work. That is why page wise you will have to keep the PO.
BO2, I have given my lord. Tax figure,
Nobody is
everything is
disputing that. But
everything has
that is
been
not
given.
the price bid. Bid price is in form number 6.
I have given everything given. So I have substantially complied of my form of bid also. That are my humble submission. And bill of quantity, I have given
And
everything.
section 6 is at page.
1.1 is page 1.
My lord,
The contract shall be for the whole works as described in subclause 1.1
it is a
based
scope
on the
of work.
price bill of quantity submitted by the bid.
Yes, sir.
Bill of quantity only that. Break wise you will have to show my lord for every item. But my lord, the price bid is in form 6. That's why my lord.
Your lordship kindly go to the bill of quantity document. I have annexed, my lord. Everything will be here. Page 142, my lord. Huh? 139, my lord.
139.
139. This is the rate quoted, my lord. Last page. I have given analysis. Last the total in figures 11, 18, 94, 06, 0,
Page.
page 140.
Anyway, yes, okay.
Yes, my lord. And another thing is that, my lord, your lordship kindly go one point. Form of bid document page 150. Most important thing.
Yes,
That is blank.
That we have, I have shown my in the affidavit. They are in the portal.
This is not part of tender document.
It's
my lord.
part
What
of
he has said.
other, how you have calculated it.
but you have you have also filled up.
No, my-
You have
I
filled
have-
up. You have filled up also
Yes,
at
my lord.
page 138. There is you.
What form of bid? That your
138.
lordship kindly come to, I'm showing 1 to 1.
You see, you cannot take two stands on the same thing. You
No,
cannot
my
say,
lord. I am not taking.
you
from
see,
the-
the form of bid is
Yes,
blank, on the other hand, you have
I
something.
friend has said it is a part of tender document. Page 1 to 34. There is no page number, my lord, in our internal page number. In respect of our, my lord, thing is not easy, my lord. No one get contract, my lord. That is the modified exchange of, I want to show 22.6. Just 1 minute, my lord.
Page. After this, no more. I think we've spent enough time.
My lord, lordship calendar is 59. the opening of file name of bidder will be the bid qualified fee. Will be paid. Then you will see
Page 59, yes,
22.5, page 59.
yes.
If a consequence of the modification carried out by the bidder, as one of substantial clause to bidder said easier to modify the financial bid, they will submit the modification of separate seal envelope so as to employee. And the envelope shall be clear marking modification of the finance is not to be obtained except with the approval of evaluation.
No modification, no, it's not modification.
That is not the issue here.
My lord, let me, what? 22.2, envelope must withdrawal shall be open and read of first bid for which withdrawal has been pursued plus 2.22 shall not be open. My humble submission before your lordship is that if I quoted the rest here, then they immediately sends the bid and then power has to come to the employer. I want to show malified exercise of power for
But you have not challenged this form of it. You have not put to challenge
my
it.
humble submission.
How can you say
No,
that this will be,
No,
if I
my-
do it like this, they will take advantage?
my, now, if the record has been given in respect of duly signed to the respondent number 10, my lord, which is a terms and condition of the conduct, and digital signature of product is liable to be rejected, that same report should be given to me. And I was substantially comply of financial. That is my humble submission before your lordship, my.
Just what, when the particular document is uploaded in the portal, it is locked. Only the technical evaluation committee can open it. Thereafter it is.
No, my lord, lordship.
Anyway, let us not go into that.
No, no, they are affidavit.
No, that's enough. That's enough. Yes. Yes.
Affidavit online. They have
No more.
unencrypted document, they have sent indirectly.
Sorry.
That-
Yes. Yes.
My lord has 6 clause 30.2.
Yes.
The lordship knows, Lord, when there is a consequences, it is mandatory. And Lord, it was a requirement where they have to quote the price, but in words and Lord, figure. And Lord, there is one more thing, Lord, has not been pointed out to your lordship, Lord. If the lordship would see at page 60, clause 26.
Yes.
It is as regard the financial bit, Lord, and your lordship would see that that would be scrutinized. If there is a difference between the word and the Lord figure, and one which is in the price bid, Lord, the engineer has to accept that, Lord. And if your lordship,
Wait, let us see. What does it say?
my lord, page 26.2, the amount stated in financial bid will be corrected if there is error in accordance with. If the bid prices increases or decreases as a result of this transaction, the amount as stated in the bid will be the bid price. If the bid price decreases as a result of this, then the decreased amount as stated in the bid will be bid price. Such adjustment will be considered as binding upon the bidder.
What is this bid?
If the bidder, this is form 6.
In the bid of form.
Yes,
No,
bid of
my
form.
bill of quantity.
This is a
The form of bid.
form of bid.
My submission, bill of quantity
But
also be cited.
it's not that, my lord, that I have altered or any rebate has been granted to me. Lord, the bill of quantity enlists the items and rates. And Lord, my final bid
Total,
was
my lord, totally figure.
total. And my,
Just a minute, Mr. He didn't disturb you.
and my lord, I have quoted the main bid amount in my form bid. Now, between the two, my lord, whichever is low, my lord, they can accept it, my lord. And my lord, if I don't agree to participate or execute the work, the consequence will follow. And that has been written, my lord.
Okay. Right.
Only one thing, affidavit that may be my lord recorded, they have said without any encryption, form of business affidavit.
My lord will only one thing, your lord.
Because your lordship can para
There's no point. There's no
No,
point.
no.
para
Right.
170, page 170.
No, heard Mr. NNP Chaudhary, learned counsel for the petition. Also heard Mr. P. Gogoi, learned standing counsel for the PWD, and Mr.
R. P.
R. Dubey, learned counsel for the respondent number
10.
10. The petitioner's case is that though his bid was technically responsive and was declared as L1. Was it declared as L1?
He said,
No,
I
no,
was
not
declared-
declared, not
No, my lord. He said, I
And was declared as L1. He has not been awarded the contract. He in respect of NIT dated 4/7/2024 for construction of 33 kV dedicated HT line from, this is para 2 it is there, that work, okay, para 2 of the order dated 6/9/23. The petitioner's counsel submits that the contract has, however, been, no, it's not been awarded to anybody, no? It's not awarded to anybody.
Now, my lord, the respondent number 10 has been considered as L1 as per the finding. At page 1 of the.
The petition is the, 169. The petitioner's counsel submits that the respondent number 10
Yes.
has now been considered to be the, to be L1 in terms of the minute of the financial bid evaluation committee meeting held on 6/8/2024. At the, at its quoted rate of rupees, which one?
My lord, here the respondent 10 has been considered as L1. We have mentioned
Yes,
that.
yes,
Yes, what you will find, my lord.
at which rate, the two rates,
Oh,
as
yes,
per
my lord.
form of bid is 10, as
Yes,
per form of
bid,
bid,
as per
as
the
per
form
the,
of-
as per the amount quoted in its form of bid, which is rupees 10,50,03,707. While its quoted amount as per the bill of quantities was 13,32,87,26. Next. The petitioner's counsel submits that the petitioner's bid has now been treated as non-responsive as in terms of clause number 13.2 of the NIT. The petitioner's counsel submits that the submits that clause 13 submits that the bid prices, no, submits that in terms of clause 13.2, a bidder is to quote his bid price in section 6 bracket form of bid bracket close, both in figure and word, which is to be duly signed by the bidder. It submits that as for the form of bid was in an unencrypted form, comma. If the petitioner had put his bid price in the form of bid, comma, the other bidders would have immediately come to know the price being offered by the petitioner, and they would have had an opportunity to withdraw their earlier bid amount and make an amendment and make a new bid offer. As the same was, as the same was allowed in terms of the NIT. He submits that to overcome the difficulty, he submits that to ensure that the other bidders would not be able to know the price bid of the petitioner, comma. The petitioner had in serial number 1 of the form of his form of bid stated that the offer to execute the work would be as per the quoted price in the bill of quantity. Correct. He submits that as the said declaration had been made by the petitioner in the form of bid. The price bid offered in the bill of quantities should have to be considered as the bid price in the form of next one. The petitioner's counsel submits that the respondent number 10 could not be declared as the declared as L1 and L1 in view of the fact that the form of bid submitted by the respondent number 10 had many blank spaces which was mandatorily required to be filled up. In this respect, he submits that paragraph number 6 of the form of bid submitted by the respondent number 10 shows that the respondent number 10 had not appointed any person as the dispute review expert. There was the column regarding witness and address was also kept blank. There was also no signature on behalf of the respondent number 10. He accordingly submit that the declaration of the respondent number 10 as L1 being not being could not have been done as the form of bid submitted by the respondent number 10 was not complete in all this. Next para, the petitioner's counsel further submits that in terms of clause 13.1, when there is a difference of the price bid in the bill of quantities and in the form of bid, the price bid mentioned in the bill of quantities would have to be considered to be the price bid of the bidder. As such, as the petitioner had stated in his form of bid that the price bid in the form of bid would be in terms of the price bid offered in the bill of quantities, the price bid, the price bid of the petitioner would have to be considered in terms of the price bid offered in the bill of quantities. What else? Anything else?
I have successfully complied with the
Yeah, he submits that as as the petitioner has substantively complied with the requirement of the form of bill.
And event,
Huh?
event with the respondent number 10, this of form of it.
Full stop. On the other hand, the the respondent number 10 has given his price bill in his bill of quantities as rupees, what is that? 169. 41 paisa. Huh? Page 144. Or 169. No, that's 169. As 13, 32, 87, 265. While in his form of bid, he had given rupees 10, 50, 03, 70. Though the state respondents were bound to accept the price bid in the bill of quantities in respect of the price, two different price bids quoted by the respondent number 10 in terms of clause 13.1 of the NIP. The respondents have, however, accepted the price bid offered by the respondent number 10 in his form of bid, which is not in consonance with clause 13.1 of the NIP.
Next section has been given to respondent for paid matter in respect of accepting the proposal. That should be given.
Okay. And plus, he also submits that as the state respondent the had accepted the uh, form of bid submitted by the respondent number 10, even though even though he had not supplied all the information required as per the form of bid, comma, the same relaxation should have been given to the petitioner in respect of the petitioner not submitting the price bid.
Form of
The price bid in the form of bid as required under clause 13 point of the NI. He accordingly states that the petitioner's technical bid should be declared responsive, and the declaration of the petitioner's technical bid as non-responsive by the technical bid evaluation committee. Huh? Financial? Yeah, by the financial bid.
technically we call it
As the financial bid, huh? And as the and the declaration of the petitioner's financial bid is non-responsive. Should be settled. Next, Mr. P. Gogoi, the learned standing counsel for the PWD submit that a reading of clause 13.1 and 13.2 of the NIT clearly goes to show that there is there clearly goes to show that when there are two different price bids in terms of the bill of quantities and in the form of bid, there is nothing. What the price bid quoted in the bill of quantity uh, huh? The form of no, which will override the other. Form of it will override the bill of okay. Whatever I said, bill of in the price bid quoted in the form of bid would prevail over the price bid quoted in the bill of quantum. He further submits that clause 13.2 clearly provides that the price bid has to be submitted both in figure and in word, which is to be duly signed by the bid. A financial bid without any mention of price bid in the form of bid shall be treated as non-responsive and shall not be considered for eval. He submits that the said clause being an essential condition of the tender document, of the tender condition, there was no infirmity in declaring the petitioner's bid as non-responsive, as the same had not been adhered by the petitioner. Mr. R. Dubey, the learned counsel for the respondent number 10, reiterates the submission made by Mr. B. Over, learned counsel for the petition, PW. He further submits that he however submits that in respect of page 60, what did you say?
Right, it is not a error. Right. But I am- it-
26 point.
that's the form of- yes, that's the- not a-
Where does it say form of bid? Huh?
He- he- when there is the date, certain one. Certain words are there, not the of-
Where?
keep it. Not- The bid is the declaration of the bid, or is it- but it also sets the position where there should be a lot change in the price. Therefore, blood reason then also I have to accept it execution of. If that does not accept the correct, it will accept the. The form of price quoted that has.
Where does it say form of bid price? Where does it say form of bid? Where is that word?
That mandatory condition is there.
Why? I do not know why you want to add something which is not there.
One more thing, madam, from our side, madam, the cancellation or rejection of the financial bid of the petitioner. Madam, there is no such prayer, madam, for parting of the in the report, madam.
Oh, that is all right. Okay. That's one. Okay, you cut that second portion, huh? Then right, I have heard the cause for the part. Now, with regard to one aspect, Mr. Gogoi, that respondent number 10 also did not sign.
But signature is not a mandatory good. My lordship will see the last line of 13 after that. Why we have rejected
No. How about respondent number 2?
without,
It says both in figure and in words,
No, no,
which
no,
is
the last
duly
line.
signed.
thereafter last line.
Ah.
A financial bid
Uh,
without any mention of bid price in the form of bid shall be treated as not assured. So the main mandatory part is, my lord, that price will have to be met. That is the.
okay, you just said one thing, huh? Mr. B. Roy further submits that the case of the petitioner and the respondent number 10 is not similar in as much as in as much as the failure of a bidder putting the signature in the form of bid. Or is it there?
It is
Okay, he said it's not
Page
there.
144 it is there, madam.
Oh,
Not a digital one,
Not
but
said
it's there.
to be digital.
No,
It
it's
is signed.
there. Putting some condition on the.
okay, for we just put Mr. R. Dubey, Mr. R. Dubey submit that the signature of the respondent number 10 is present in the form of bid. though it is not a digital thing. I have heard the learned counsel for the party. Clause 13.1 and 13.2 states as follows. Clause 13.2 clearly states that a bidder must quote his price in section 6 bracket form of bid, both in figure and word. But in the present case, the petitioner has not put his bid price in figure and clause 13.2 further states that a financial bid without any mention of bid price in the form of bid shall be treated as non-bid. The same clearly goes to show that failure of putting the bid price in figure and in word would entail the financial bid of the bidder to be treated as non. As the petitioner had failed to quote his bid price in the form of bid, both in figure and word.
What I can
And the as clause 13.2 has clearly it has and as clause 13.2 has clearly uh, clarified that the same would that the financial bid would have to be treated as non-responsible. This court does not find any information with the decision of state response. There is decision according this way. Later on, we put some judgments in the case of the.
well, I have a judgment.
But the employer, is the main authority to decide, and the project,
Huh?
the employer is the main authority to decide which clause is mandatory. 2022, volume 6,
Yes, I did.
Well, I have two judgments.
2022, volume 6, SCC 1 to 7. There are 17, 22, and 20. There, all judgments have been happened. If it's
I-
right, I will give you a picture of this.
I've given Tata Sinudar minor. The Malachite exercise of power minor for collateral purposes.
I
If they
Indian, nobody has been made a party, but it's a LS.
minor, may submit. I'm a small lawyer. It is allowed me to. Minor, Malachite,
Small lawyer, with a pinch of salt, huh? Being sarcastic.
yes, minor. So I get my to get that. My
You know, what is the word called in English? Pretending to be feeling small. Yes. So how does it help?
Help my lord. I have given page number. And one is another is that important judgment is that my lord, central court case. Paragraph 55, my lord, the lord says no, categorically stated that if you look to the my lord, clause of the tender, it should be looked, my lord, as a whole for both the bidder, not for one bidder. That may be the record. Central court. I can the cite this.
Yes. Yes, Mr. Counsel, what to do? They are saying that Puja fair, what Durga Puja. Huh?
It's absolutely based on FTN. So the fact is that some documents, the application was there, initial application was there, on the part of the petitioner as well as on the part of the private respondent. Thereafter, no communication. Circular is very clear with regard to the fact that the competitive bidding is there on 2%.
No, was there any bidding? They are saying that there was no bidding, there was no NIT, nothing.
Exactly, Lord. Because whatever the averment is there in the writ petition is absolutely presumption. Because there is no Substantial
No,
element.
no, so what is your, so what is your instruction? Any instruction?
Then I will get the instruction by tomorrow, Lord. Okay.
Yes, that is why. Right, Miss D. Chaudhary, learned counsel for the petitioner submit that the petitioner intended to organize a mini fair in connection with Durga Puja on railway land adjacent to rest camp Kalibari on temporary license basis and accordingly submitted an application for permission to do the same. On, when did you submit?
On the
The annex 1 law,
annexure one.
Page
page number 70,
on
27A.
27/8/2024. The grievance of the petitioner is that without taking a decision on the petitioner's representation, comma, the the state respondents have allowed the respondent number 8 to no, the apprehension actually. The apprehension of the petitioner, not the grievance. The apprehension of the petitioner is that as the respondent number 8 has also submitted an application for the same reason, comma, the same may be allowed in the case of the respondent number 8 without there being any selection process. Selection slash tendering process.
Tendering.
Mr.
FPQ.
F.P. Chaudhary for the railways submits that he will obtain instructions. Raise the matter tomorrow. Last minute, madam, you come. Puja is this. Yes. What to do, Mr. Nayak?
I can say very much. What if I will satisfy your logic from the right? That's all the ground your logic says. Yes,
Okay.
I not actually. Suddenly, I'm taking the second one. Cover the first one.
Oh, we'll dispose it off.
Possible issue notice.
Then there's no point if I'm going to issue notice. No.
Yes, that
We'll.
has to be decided.
Yes. Okay, just take down the order, the last order, huh?
Yes.
Last order, para 1, 2, 3. Okay, 1, 2, 3. Okay?
Four grounds were here. The first one is non-fulfillment of the.
Anyway, I'll just reproduce it. 1, 2, 3. Then you just say issue notice returnable in 4 weeks, 3 weeks.
But Lordship is taking the interview.
Yeah.
I will have to issue the work order. Otherwise, I have received instruction not, so I can satisfy you.
Okay, that's fine. Otherwise, I'm planning to continue with the interim order.
That is it. In other cases, they have already this work order.
Okay, that
Only case to take it.
is item.
Item lot, I'm taking 5118, which is the second.
Yes.
Lordship recorded 4 grounds. The first one is criteria of 3 years experience. Second is non-fulfillment of criteria of that annual average of 25 lakhs. Then liquid asset of 50 lakh rupees, that's the third ground. And fourth ground was that minus 81%. Putting up minus 81%, that abnormally low, last outside of the range of last. So I'm straight coming to the point of 3 years experience. Once they come to page 11199. One time.
Yes.
That is the PAN card of the society. It is an NGO. Not may kindly see the date. It is 31/1/1977. So this society exists in 1977. And Lordship,
Which society? Petitioner society or
yes, the respondent.
respondent society? Who is the respondent here?
Orion
Okay, yes.
exists from 1977.
Then lordship may please come to page 218. 218. 218 is a certificate issued by the executive engineer, KFC, etc. Lordship may kindly see this is to certify that the NGO named the Orion Society had been working for door-to-door garbage collection of the KFC from July 2014. July 2014 to still now at ward number 46. So we have the experience of working 2014, more than 15 years. And Lord may please come to page 219. 219 next page, Lordship. This is the same another certificate, Lordship. Here it states the Victorian Society is working since October 2011. Yes. 220 Lordship with the page 20. It's a letter of intent dated 16/9/2019. Yes. This was the work allotted to me in the year 2019. It also reflects that we have more than 3 years. 222 Lordship. Yes. Another letter of intent. This was from the period 2014 law. It is dated 17/7/2014. So he is doing the same work since 2011. Yes, okay, that's all right. Now. But here, Lordship makes this. What about the bid amount? Yes, the person has bid amount is 9.5 per house per month. Now that is now. That is what. Now the base rate is 50 rupees. Now this point is concerned of that clear now. More than clear. And that 198. 198. Society exists. How can they grade the 2020 and 21? I'm coming to the same name. What actually has happened? They registered in 2021-22. Yes, sir. But Lordship has seen he is working since 2000. That is a different end. Lordship, what is it? What happened? That this is a society which has registration prior to 2020. But as per the law, if the certificate gets there, the Act did not have any provision of renewal of the at that point of. So they can bring that. So accordingly, that notification also I have. I mean, okay, so that is all right. Now it has been amended. If their society registration had expired, and they got a subsequent registration in a different year, but it is only different number. Huh? Security. Yes, new entity. It is not called renewal law. You have to take a care. It's a new entity. We cannot register the same. If they are registered the same, that is something. It was subsequently, the law was subsequently amended. That law. And now it is allowed that if you are already registered and your registration got left, you can substitute it. Let us see the law. Let us see the law. We have to see the law. 21, they are not allowed. Because labs, there's no existence. They have come up with new statement. Okay, how do you overcome this 9.5? I'm coming to that point. Not if earlier what you should have done, be it domestic or be it commercial. The individual has to pay for the same. Now the new system has to pay for the same. Yeah. I mean, if I am a domestic household lot, and the contractor is collecting service from my house, then I am. Government has no money. But now the system is not. Super domestic are from India, government will pay. Government will pay. However, as regard commercial sector, they will collect from the commercial sector. Now here lordship, the area lordship, is case fully commercial. And for that, a separate notification. No, but then, look, that may be, but then as per your NIP, lordship, what is the base rate? Whether it is, whether there was any distinguishing factor or was there any distinct? I'm
Not in that terms, not will find one notification at page three. Page three.
of your this.
Yes. One notification is
Have you given him a copy?
not yet. Not. It's a government notification, part of the act.
Is it?
But why we have done explain. Okay, please come to serial number 1.3. This notification is was issued under in exercise of power under Rule 30 of the Assam Public Procurement Code. But now the system of rejecting a bill on the ground of low rate quoted by the contractor has been abolished, almost abolished.
Almost abolitive.
Yes. Not if all that-
Almost, then you see, then why should it have been put in the tender?
No.
You cannot,
that
you cannot have your cake and eat it too.
No, Lordship will come to the last page of the minute clause. On what condition we granted them the contract, awarded in the advance data. Page 235.
Yes,
Last column, Lordship will see the performance record.
yes,
That's package number 13, Lordship. Lordship will see his performance security was good.
package number,
Package number 13.
package number 18,
It is just 13.
13.
Yes.
13 is at Orion Society,
Orion.
yes,
Okay, last column, Lordship will see performance security 8,30,000.
correct.
So others are required to give 5 lakhs. But here additional security was supposed to happen. Only because of the low rate quoted. That is the provision of the act not finance. But kindly to 1.3. 1.3. If after evaluating the justification and price and
1.3 of what?
1.6. First page, page 3, page 3. This is 1.4. Page 3, 1.3. If after evaluating the justification and price analysis, TIA is not satisfied with the justification offered by the bidder for quoted price lower than the threshold value, the TIA sells the additional performance security to protect against default. So that option is available. And secondly, Lordship, what refer to the clause?
Huh?
Clause. Clause the page. Clause says they have to evaluate on the asking get ask them that is not a what law firm that is a
Yeah. No, that's
says they have
yes, that exercise whether it was done on.
Yes, sir. Now, Lordship, it comes to case 52. Case 52. Abnormally low bill.
Yes,
Lordship, kindly come to 37.3.
yes,
After evaluation of the price analysis, in the event that the procuring entity determines that the bidder has failed to demonstrate its capacity to perform the contract or the offered bid price, the procuring authority it reserves the right to reject the bid.
correct.
So it is not automatic.
Please come to 13.7, 37.2.
In the event of identification of a potentially abnormally low, the procuring entity shall seek written clarification. It is nowhere stated that it was not protected. They
Let us see whether you ask for written clarification from the
Yes.
bidder. Let us see.
he was asked,
No, wait, that you have to bring that.
that's why I will bring now.
You bring that.
My affidavit not to find it.
You bring that whether he was asked clarification and whether the detailed analysis of the rate was made.
Yes, it was analysis, and that is why that provision law. Okay?
No, that law is okay. We agree with your submission.
Page 67 law. I simply I am showing that why it is not, it was considered justified. Page 67.
67 days.
Last bottom lot.
Yes.
PL. TMC shall make the payment to the contractor for performing work and providing services as follows. For daily door-to-door collection and transportation of MSW from houses residential, the contractor shall be paid by TMC. Based on the survey data and detailed monthly report, FC per household has 6 financial bill. For the daily door-to-door collection of MSW from hotels, restaurants, division, other various commercial, TMC will not make any payment to the bidder for collection of MSW from the restaurant, office, division, other various commercial, but shall authorize the bidder to collect monthly fee from these waste generators for providing service of daily door-to-door collection and transport against them. So that provision is already there. Here we are only in concerned with the door-to-door collection from households. So that area being entirely commercial area now. The rate will be completely different there. That notification is already there, having separate rate for the commercial. So this 9.5.
No, but then the rate analysis has to be there anyway.
It has been done. That is,
You bring that with then, without that, so we cannot be done half that. You bring that.
only through which I have concerned. He is being a non-technical bidder. Now he is running collecting the garbage.
That is
And
what that is his intention. that
Any
is-
interim will help him out.
That is his intention.
And why not if come to his representation? His representation at page 234. 234. Why it is motivated now? Notified this is a very small representation. Here he has complained against serial number, package number 9, 12, 13, 15, 16. Petition is only on the respect of 13. 13 because he is collecting the garbage from, package
Thirteen.
number. That is his interest.
Anyway, you find an affidavit, we'll issue notice once because you find the affidavit within 2 weeks. We'll take it up as soon as we open. Otherwise, you see, I cannot take a decision which will basically amount to disposing of the writ petition without the necessary document. If you can show me only one aspect, okay, one is that the rate analysis of Orient that you did. That is one. That is required. And number two is, of course, you have to answer the question with regard to the Orient. They being their earlier registration having expired. The document. So Orient might want to say something.
Secondary logic, even if this petition is allowed, will not give him any benefit.
That
That is your logic.
that is not the issue. That's not the issue. You see, that is not the issue right now.
So indirectly, he is getting benefit. That is the only thing. Even if this petition is
Your bid was rejected. Your bid was rejected.
helpful.
Help.
This is logic.
Can state the arbitrary deciding people when
Okay, he was L4. So L2 and L3 are there also.
In between L2 and L3 are there.
we have no paper.
So even if this petition is allowed now, he will not get the benefit. But indirectly, logic is getting the benefit right now.
For the time being.
He will continue to get that till the disposal of.
I can make it partnered also. But the problem is no notice has been issued to the I understand your point of view. Only problem is there's no time to have such a especially when there's no affidavit or when the records are not there.
Parawise comments I have already.
No, but
The
the
Parawise.
rate analysis you have not
Yes,
mentioned. I
may
think
kindly come to page 19 of this part.
19. Yes.
Document kindly come towards the end lot. Single envelope meeting.
Yes.
Furthermore, the basis of rupees 50 is the previous uniform rate made applicable for coordinated study. The package under reference covers urban and highly commercial wards, and the rate quoted for household INR 9.50 per household excludes the commercial establishment collecting rate, notified commonly. The abnormality as such cannot be substantiated, considering the bidding being a compact public sector social project, and with exclude payments from commercial establishment and notified rates. The notification issued by Finance Department notification of the direct seeking additional securities for the rate, even if the rates are unjustified. Full clarification. The tender inviting authority has imposed such additional security, considering the rate to be unjustified. Furthermore, in line with the bidding document, the agreement draft has made a part of the bidding document and attached as section 8 general conditions of contract, supplemented with section 8 special conditions of contract as the clause equals for detailed and covered all liabilities, including professional liabilities, with of contract transaction under the contract.
Your rate analysis is not important.
Their analysis was basically on the ground of domestic.
No, but still, rate analyzing required. So that means though they don't have to submit any bid. So someone will submit ₹2. Will it be justified? When someone will submit a rate of 50 paisa, will it be justified? You've got to think of it in that line now.
But it justifies it only the contractor will get the money that is collected from the commercial.
Correct.
Domestic household in that area is very low, very few.
Correct. But then no, my question to you is, supposing someone had asked for said that, okay, my rate is not 950, but it is 50 paisa. Then what will your argument be?
The scale of that is what I'm saying. That if he can continue his collection not at that rate level, we have no objection.
So that means a person who said, okay, 25 paisa I will pay.
He is 30.
Rate analysis will be required. That is sure. Otherwise, how will you justify? If you justify 9.5, 9 rupees, 50 rupees per house, or per shop, or whatever, or because if it's a shop, they are not collecting from there. Then what is the rate being given by the GMC to that collector for collecting per shop?
Per shop lot we are not giving. It's often arbitrary. From the shop lot you will collect of his own.
He will collect off his own.
Directly collect from the property. Only for the household plot we are going to be paying at the rate of.
So for the shop, so for the shop,
What a stop lot for notification is already there, the rate is already fixed rate is already there for the command. We are not going to touch that.
so why do you give it out for? Why will anyone do it for free
For domestic.
for shop? Why will no for domestic? So he has to no for domestic you are paying, correct?
Otherwise, he will not be able to run his operation. It's like earlier domestic also you used to pay him direct. From DCL notice for domestic we are good.
But that's not commercial shop where they'll be collecting without being paid by the house.
Correct.
And
That side is there's no.
in that situation,
For them to take it without me putting the rate. So these two.
let us
required,
operate
but
that.
one fee.
Let us operate that collecting. Let us operate on our own. Why the big?
You file an affidavit, you will dispose it of on the next day as soon as it's reopened, just 2 weeks later. Because right now it's difficult to dispose.
I understand now, but
You give me the rate analysis, only that. Please verify this. Because okay, for household, so you pay. And for shop, you don't pay. Now if GS Road, the even GMC has got no role to play for
so far as garbage
garbage collection.
not done by the contractor.
Correct. Then what is the requirement of
No, in there are areas.
there are some areas where they
residential
stop.
areas. In residential areas, it will different. Suppose in
I think
peaceful area lot, where
it-
the
I need-
entire area is
it needs a little bit of waiting. It needs some time. I don't think I'll be able to finish.
I'm only playing the liberty that if the authority wants, then they may of their own select setup. That much liberty I'm, because he is the time,
It L4.
that issue cannot be ignored. Even if it,
Your L4, Mr. Council.
That you admitted, what you're submitting, the evaluation prepared as per the.
that your lot.
That
No, yeah, we'll take it up on the next day. Right. Heard Mr. D. Deka, learned counsel for the petition, and Mr. P. Nair, learned counsel for the PM. After hearing the counsel for some time, this court is of the view that the GMC should file their affidavit, especially with regard to the rate analysis done by the respondent number 3. Next up, to notice, returnable in 2 weeks. Mr. P. Nair accepts notice on the respondents number 1 and 2. Petitioner will take steps for service of notice upon the respondent number 3 by registered post within the course of the day or within 2 days. In addition to the above, the petitioner shall serve notice upon the respondent number 3 by registered post by way of dusty service within 10 days and file affidavit of service there. List the matter on. See what it is.
First 23rd.
23rd. 23rd. Then
The vendor will have 6 days. That is 91%. Like, let's say the interim order. Order to public in the way. Like,
yes.
the justice order days are 25.
Huh?
Justice pass order are there. But here is guided. But the reference 4 and 5. Issue the license to stop. And appropriate 5.
Okay.
And if you take 10 days,
This pose of the who is for the thing? Who is for the
Number EN4.
the other person? Who are the council? No council. No one. Oh, that means.
at 2 p.m.
Huh?
At 2 p.m.
Who is the council for phone number 3? Municipal person.
Yes, this matter. Yeah, but by because matter thing.
No, it is not that. It is not part. You see, it is set subject to the renewal of the license. Now that license has not been renewed, let them take a decision. That's all I'm going to say.
And then matter, yes, file also.
What is this review?
Yes, ma'am.
Review? No.
This was.
This WPC. Review will go.
Yes.
But this WPC is not part. That's the part. Because the order says, fill the order.
Last was not at least 30 minutes.
Order says, however, the president's license for has expired and the renewal application is pending before the municipal board. The petitioner cannot continue their business until the renewal of the license given by the municipal. Now, despite this order, they have not taken a decision. So they want a decision to be taken by the municipal board. That's all. So where is the red indicator? So we will direct the respondent to decide.
That purpose matter, they have also filed review petition also matter.
That review will go. They will withdraw.
So I will do this review.
Review.
Yes.
You withdraw the review petition.
Yes, I will do so.
Right.
Not because my lord, no, review to another part.
There is one review petition is accept by not item.
Okay, right. Third, Mr. A. Mohammed, learned counsel for the petitioner who submits that in terms of the order dated 13/6/2024 passed in WPC 4605/2022, the petitioners the petitioners were allowed to run their shop prior to the petitioner's application for renewal of their license, business license being allowed by the municipal board, by the which municipal board? By the Sonari Municipal. The grievance of the petitioner is that the Sonari Municipal Board has not taken a decision on the petitioner's application still. And as such, they pray that a direction be issued to the Sonari Municipal Board to take a decision on the petitioner's application. Issue notice returnable in 2 weeks. Mr. M. Chetia accept notice of your phone number 1 and petitioner takes steps for several notice upon the response number 3 and 4 by registered post with AD within 2 days. In addition to the above, the petitioner shall also serve notice. Anything? Does he service also? Or no? No, okay. Okay. Within 2 days. This is the matter. Yeah. 2 days. You make it returnable in 3 weeks. Huh? 46 days. Same. Or but WPC the number will be different.
Yes, WPC number is 517.
5171.
And below item number 37, review petition method. I will be allowed to.
Okay, right. Item 37, you write. Mr. A. M. Ahmed, Learned Counsel for the petitioner, says that he may be allowed to withdraw the review petition. Mr. M. Chetty appears for the state respondent. The pair of the petitioner's counsel is allowed. The review petition is dismissed as written. Yes. Toilet.
I have.
Basically, she's saying that this the toilet on the western side has been allotted without NIT.
Okay, but just now I have checked the.
So what to do? We if you notice. Yes, sir. Yes, right. Right. Mr. PH format. PH format. What? Let's process for the petitioner who submit that the toilet on the western side of the ISBT has been given to the respondent number 3 and 4 without issuance of any tender. Correct? Issue notice. Wait. Tender. By order dated. By letter dated. By letter dated 12/9/2024. Issued by the Managing Director ASP. Brackets, respondent number 2. Issue notice returnable in 3 weeks with RM Deca. R Deca. Accept notice on behalf of respondent number 2 while the MD board accepts notice on behalf of respondent number 1. Petitioner takes steps for service of notice upon the respondent number 3 and 4 by registered post with AD within 2 days. List the matter after 4 weeks. 3 weeks.
Outlet.
We will think too much.
The issue is very simple.
Ah.
Okay, the petitioners managing committee has been running the Bihapuri Saturday weekly market. Okay? And thereafter, Lordship,
The petitioner has been running the weekly market
Lordship,
from a fixed period.
Lordship, from 1/9/2023, Lordship. I take a letter of agreement dated 1/9/2023, Lordship, character G, Lordship. Page 31. Lordship.
Okay.
Lordship, thereafter, what had happened, Lordship, a cabinet decision was taken, Lordship. Kindly peruse page 32, Lordship, annexure A, Lordship.
Yes, yes.
In the intervening period till new tenders are issued and bids are made, the present lessee will continue to run this market at previous settled rate. So what had happened, Lordship, the respondent authorities allotted the state market to the
This is
private
a,
respondent.
this is a cabinet. Where is the, I put, this is the 29/6 notification.
But if my simple submission is that I have submitted one representation, Lordship, then maybe.
I don't think whether this market can be done, can be carried on by the erstwhile lessee.
I am only for again for our paper number 2.
You see, how did, you see, who are you
I am the president and secretary
of the
managing
petitioner? Now, this market has been
allotted to a private respondent.
allotted to a private respondent, and who are you to run the market?
Lordship, we are running the market on the basis of this agreement. Thereafter, cabinet decision was taken.
What agreement? This page 31 is your agreement.
Lordship, 19/2003.
Correct. That is Bihar Guri Cooperative Society.
Lordship,
Who is this Trilok Mohan? Who is he?
Lordship. He is the
Who?
president, Lordship. He is
He-
the president of the managing committee and
Okay, he is the president of this Bihar Guri. Okay. Secretary.
petitioner number 2 is the
Yes,
second.
what is to be done?
My lord, Parma say, my lord, it's look like, my lord, it's not a government market under but directly. It's look like, my lord, page 31. It's the land of some cooperative society. They have signed agreement, my lord, with the management committee of 2020.
Lordship, but Bihoguri development block is there. So, Lordship, we have submitted the representation to the chief executive officer, Jila Parishad.
Notification, 29 notification will not
Cover this case.
that's the different game.
But my full prayer is to consider.
Mr. Counsel, your simple claim might look innocuous, but I do not know if it is innocuous. It might be simple, but not innocuous.
Okay.
Huh? You tell me one thing, is it a government market or what is it? Government land or
It's a
private land?
government then under Bihoguri development block. That's what number 4.
But who allots the market? Who settles the market in it?
Lordship, there is nothing, it's called, it's under the government. Correct. Lord, may I read, my lord. This agreement was signed between the Saturday Weekly Market Management Committee of
Committee.
so and so. According to this agreement, the Saturday Weekly Market will be held within the premises of the cooperative society. From so to the cooperative, and the cooperative society has no objection to held inside the cooperative premises. So its market is inside the cooperative premises, not the government.
But kindly schedule clause C of this agreement. Clause
Yes,
C.
clause 3,
Clause C, Lordship.
clause 6.
So this agreement shall be terminated immediately upon an order from the district administration. No order.
Maybe, but then the district administration has not given you the,
Yes.
has not settled the market with you. Why should the district administration? That may be a very cunning way of putting in some authority who has got nothing to do with this settlement.
Yes, my
I mean, in this case, my lord, there's not a very good document. If it's not a clear. That's what
Correct. I do not know what is brings about. Who are the party?
Lordship.
State of
page
Assam.
3.
Where is the state of Panchayat and Rural Development?
Lordship, it is
District, DC,
Lordship,
Chief Executive, Jila Parishad, Block Development, Bihar Guri Cooperative Society. Huh? What is this? Just a minute. The respondent number 5 is the Bihar Guri Cooperative Society Limited. And the petitioner number 1 is the president of that Bihar
no,
Guri.
no.
Yeah? No.
it is
Petitioner
the president of the
Weekly
management
market.
managing committee
Huh?
of the Bihoguri Saturday Weekly Market Union Committee.
these are their personal differences, my lord, and they fight with me.
This is not even Gram Panchayat. This is Weekly market Unayan committee. Where is this Unayan committee?
Lordship, that market management committee Saturday weekly market. I have stated in my return that is also known as.
Mr. Council, please come to page 30. It says a Saturday weekly market management committee of Tumuku Ground Panchayat. Now you come to your the petition number 1. President Biharpuri Saturday weekly market Unayan committee. Now where is this? Where is he? He's not even in the letter of agreement.
No, Lordship. This market, this union committee is also known as management committee also. This I have clearly stated in my return.
It's known as what?
Lordship, Ihoguri Saturday
Weekly market.
weekly market union committee.
It is known as
This management committee of Saturday, market management committee of Saturday weekly market.
Saturday weekly market management committee.
Lordship, that I have stated.
Now, why do you want any permission? Who has given permission to this to the petitioner to run the market in the first place? Where is that? Give me the letter saying that permission has been given to you to run the market.
Okay.
Because you have given it to this Biharpuri Cooperative Society.
No, Lord, the letter of agreement speaks for itself. Because it is an agreement between the Ihoguri Anchalik Panchayat, Ihoguri Cooperative Society under the Ihoguri Development Blocks.
Mr. Council, petitioner number 1 and 2, they belong to the Saturday Weekly Market Management Committee.
Lords.
That is what he says. Huh? What is the union?
Union committee is a different, my lord, market committee is a different.
That's okay. That's different. Union will be what?
Development.
Development. That is what? Okay.
They are known by the two names. If you see, it was Lordship, I have
They,
stated in my.
they are challenging the page number 31.
Ah.
And
Okay,
if
they're
are
challenging
saying-
page number 31.
No, Lord. My
He's not challenging page 31.
basic contention is that Lordship, without any notice, without anything, they have terminated my letter of agreement, Lordship, by giving the market to a private respondent. In this regard, we have submitted one representation that has not been done. That is the case. Page 33 is the representation. Positive
Just a minute. Look at the press. No. There's something wrong. You show me the you show me under why should you be allowed to run the market? Who will run the market? Nothing is shown in page 31. Who is going to run the market? Nothing.
Right. As he is my friend, is going on before the middle of this one, is number 33. And actually some things are also there. Ultimately, it's supposed to consider this.
No, but why?
These things are actually discussed.
Yeah, next third people.
We'll take it up after the figure. Right. This is matter after the meeting. Huh?
Or does there mention item 41? I am for the particular
Item
41.
41.
Affidavit in opposition has been filed by the respondent agriculture department. Veterinary department. I'd like to find my reply.
Okay.
Can it be on 29, my lord? Can be.
Okay, Mr. B. Gogoi. Submits that he has been furnished a copy of the affidavit in opposition when?
My lord, it was served on my Monday.
Monday, that is.
21 first.
On
Point
110. He accordingly asked for time to file a reply to the same is allowed. This is the matter.
for 29.
29.
I hope so. There is an interim that
Interim order to continue to the
49.
Where?
The particular was settled with involved for 7 years. Or 41 plus 20. And then after settlement, for 5, there is a settle for demarcation.
No, settlement done when?
41 plus
4-1,
2023.
23.
Got
Then,
Then it was submitted different section, then managing director.
so possession given to you or not? Not given.
Possession, not actual physical possession of not.
What do you mean physical possession not given? What? What? Spiritual possession was given or what? What? What do you mean the physical possession?
Lateral settlement order, it is there.
Okay.
Possession.
You cannot go by that.
I have prepared,
So basically,
I have filed a representation. It's 35. That may be difficult, but till then,
but what is your claim? What is your
demarcation got it and my. Yeah, notice was issued for claiming some amount. I have already deposited 9 lakhs. 37.
so you have got to deposit another 10 lakh.
They may settle this question. I'm approaching from the very beginning, very far. Till then, what is
Yes, Mr. Sharma, what to do?
Here, now all the registered things that did not take up position is not in, but after signing the agreement,
Correct. Deemed that is for possession. Huh?
means that they are paid. After 1 year, they are saying that no, they are not. After 1 year, this
Correct. That is that. He is saying that possession is only on paper. We do not know. If you said possession is only on paper, what is the court going? How is the court going to decide a case on the basis of paper or on the basis of verbal oral submission?
immediately after settlement I approached them.
Maybe, but why did you sign in the first place? You have signed with open eyes.
agreement is not being annexed or
I have limited representation. They must decide again.
I do not know whether your representation can lead to supposing they reject, then you will challenge that, leaving the entire issue. Huh?
They have several communication with the deputy commissioner also. I have annexed.
Yes, what to do? Huh? No. So what is your answer to it? You say yes, no, maybe what?
Representation we can decide on merit.
Right. Third, Mr.
MQ.
M.K. Hussain, Learned Counsel for the petitioner, to submit that the petitioner, that the respondent number 3 floated NIT dated 4/11/20 for settlement of Lali model bill in Morrigaon district. Huh?
Meanmore, typographical
Huh?
Meanmore.
Meen Mahal. Malali Meen Mahal. In Morrigaon district for 7 years from 2022, 23 to 2028, 29. The petitioner was having been selected for settlement of the fishery. An agreement was executed on 4/1/2023 after observing all required formalities. The petitioner's grievance is that despite the agreement having been executed between the parties, contract agreement, huh?
Then take 41 days.
Huh?
Can you go to page number 41? You've already paid 9 lakhs.
the demarcation of the said fishery has not been done till date. Full stop. He also submits that the representation made by the petitioner on 30/01/2026 for demarcation of the fishery to the respondent number 3 has not been decided till date, has not been acted upon. The petitioner is also briefed with the respondent number 3 issuing the impugned letter dated 18/9/2024, asking the petitioner to deposit an amount of rupees 19,10,405 within a period of 10 days during the before that, just before that, right? The petitioner's counsel also submits that the detailed representation dated 15/3/2024 was submitted to the respondent number 3. Stating that the petitioner was unable to carry out fishing in the absence of proper demarcation and the actual handing over of the possession of the. The respondent number 3 thereafter issued the impugned letter dated 18/9/2024, asking the petitioner to deposit rupees 19,10,405 within 10 days during the pendency of the representation dated 15/3/2024. The petitioner's counsel submits that the petitioner has already deposited an amount of rupees 9,43,000. He submits that the issue of deposit of rupees 19,10,405 pursuant to the impugned letter dated 18/9/2020 should not be insisted upon by the respondent. Still, a decision on the petitioner's representation dated 15/3/2024 is made by the respondent number. Mr. P. Sharma, the learned counsel for the FDC. FDC submits that he has got no objection to the prayer of the petitioner for a direction to be issued to the respondent number to decide the petitioner's representation dated 15/3/2023, provided the same has not been decided at. In view of the consent of the party, this petition is disposed of with a direction to the respondent number 3 to take a decision on the petitioner's representation dated 15/3/2023 within a period of 1 month from today. Yeah. Till a decision is taken by the respondent number 6, the impugned letter dated 18/9/2020 by the respondent number 6 could not be accepted. No, all right, full stop. In the event the petitioner's representation has already been decided by the respondent number 6, the decision taken should be communicated to the petitioner. Thank you. Your opinion. Yes. Your opinion, because he can be by the PWP and it for which to subsequently I have my database where the tenders I had submitted my tender, I had apprehended that they against that particular clause of and they reject my tender on the same ground. Then undertaking was given by the contempt court. That they will not stick to that particular condition. So the skills criteria is concerned, but they may be considered to looking to the other technical level. According to the was and therefrom they have the obviously the technical fee. So that though they have
decided the down of that particular work. But they have rejected my tender on
Some other ground.
some other.
So we issue notice.
And that might not be private account number 5. You know, pictured technically a bit, and they are financial resources and because factors that they have. Whereas my fee is much lower than the non.
Maybe, but if you have to first cross the hurdle of your technical bid being cancelled or rejected.
I'll come to that. But what I am on, 3 years, they have applied with me. Has not been applied with me. The other of the process will also be consider the technical.
So let us see the rejection of your technical bid. Where is that page?
170. Can you at this 169?
169. Page 169. 169. Yes.
This is the technical bid evaluation. So far as my for the evaluation is at page 170. Serial number 2 tenor engine. I'll come to each they have the 5 grounds they have mentioned. 5 grounds they have mentioned. So far as each concerned with regard to the experience certificate, but they have not adhered to it for rejection of my tender. E.
Okay.
That has not adhered to the fact that at page 171. In view of the above, the third paragraph, in view of the above, the decided to declare the bidder as not a para number A, B, and above.
Third paragraph. What third paragraph? Page 171. Which
The
top,
second-
bottom, middle, where?
middle, in view of the second paragraph, in view of, it is in bold letters.
Okay. Yes.
So, well, so far as I am concerned, my Lord, has seen my Lord, from one page, page number 170 to my Lord, 171, they have evaluated. So far as the private account is concerned, only one line they have mentioned. The next line of the full letter, recommended name of the technical the figure as below. Technically responsive construction, Bajaj number 5.
So the Pulen Hazarika.
But the next one, which is sequence.
Okay.
Sequence. Now your logical can be come to about point, but if he doesn't have the heat capacity at all, that has not been considered. But can we come to about
No, but then that is not what they have stated. They have not stated it. They have not stated that. That is your contention, correct?
my content, I'm supporting document I'm giving you. I'm giving you. That is a page 85.
185.
85, only 85. Plus point 1.
2 point.
Point, it is qualification requirement of bidders. Point 1, heat capacity.
Yes.
Bidder who criteria meet the minimum qualification criteria will be qualified only if their available bid capacity is more than the total bid value. Value as per clause 1.1.1. So as per clause 1.1.1 is 8.5 crore. The available
This is no, the total bid value. So total bid value is
8.5
8.5 crores.
8.57 crore. 8.57 crore.
Yes.
The bidder available capacity will be calculated as per following based on information mentioned in Annexure 6 of Appendix A.
Where are you reading now?
Same, but clause 2.2.1.
Yes.
The next line.
Yes.
The available bid capacity will be calculated as per following based on information mentioned at Annexure 6 of Appendix 1A. Now, this is at page 124. The 124 is Annexure 4 method.
Yes.
Affordable Annexure page 120. And the peak capacity given by the private opponent number 5 is at page 126.
But the additional branch is there, but all the documents I have submitted.
What is the stage of the tender process? Right?
The government for final approval.
Huh?
It has been sent to the government for final approval. So
Financial bid open.
yes, open. The private respondent of private will not do it.
There is only one response, one valid tender left. Two valid tenders. So you were the third.
No, he was
I
found to
was
be
technically-
non-responsive in the technical.
Correct. So how many tenderers were there altogether?
All five were there,
Five.
three were rejected, for three of them. Yes. Now, this document, what they have submitted, that is 36 of the edition. But
236.
calculation have been made by the serial number 3, maximum age of project that have been undertaken during FY 21-22 out of the last 5 years and include excluding amount of fee is 367. Further value updated to the price level of the year indicated as follows. Is 1.5 that is updated, so it comes to rupees 6.69 crore. Apparently, my God, less than 8.57. This has not at all been considered. It's one ground. And the language of this particular clause 2.1, when it is qualified with other requirement, then also if it doesn't have the fit
No, where is the rejection of your bid?
mine,
Where is the rejection of your technical bid?
170, 170.
170.
No, I'm saying he, that yardstick they have not applied, but I'm trying to say that he is, I'll come to my.
You come to your
Yes,
part,
yes.
so why you bothered about the other people, what they're having for dinner, lunch? You bothered about your household first.
Yes, that's if I kindly come to then page 170 of the writ petition.
There,
Serial number that is Steno Engineering as per clause 1.8 of the RFP, is the annual accounts for the last financial are not audited and therefore bidders cannot make it available. The bidder shall give an undertaking its effect and the statutory auditor shall certify the same. Such a case, bidder shall provide the audited annual report of 5 years preceding the year for which audited annual report is not being provided. However, if it is found that the bidder has not submitted the undertaking duly certified by the auditor. So far as I am concerned, madam, they say that my undertaking is not duly certified by the auditor. Madam, at page 207, my husband. Five years annual turnover has to be done.
so these are a lot of questions of facts here.
No, madam, I'm just, no, like, can you give it, I can just give you the certificate, just think, that bid date is July 2024. So the person has to deposit 5 years balance sheet audited account of the standard account. In case the latest one is not available because of the audit report until then, in that case, 5 years audited report of the preceding 5 years, that has to be submitted. And then undertaking is given by the bidder. That
So you cannot dispose of the writ petition today. First of all, these are a lot of facts these are page 170. The reading of it shows that there are a lot of facts on which your technical bid has been rejected, not one ground, a number of grounds. So it will take some time. No, I'm not deciding.
Can you come to page
Why do you want to waste time? We cannot decide the writ petition in one go.
Well, once the LOI has issued, my lord, it is only to my lord, reject it, it has been given, my lord, these are all materials from technical here.
You see, Mr. Counsel, there are two valid bidders out here. You are not the only one.
And if only one remains, in that case, my lord, it has to be retendered.
May not be. Who said?
So,
Who said?
that is,
Look at the judgment in Dependas.
that is one of the clauses that they have.
Okay, that is the difference. You have a clause, that's the difference. But there are two of them.
So, my lord, fine, my lord, he has not given the undertaking itself. The document.
You see, the issue is this. First of all, you have to show that your technical bid should have been declared as responsive. Then only can you make a challenge to the validity of the other technical bid. You cannot base your case on the faults of others or on the weakness of the other's case.
My submission is, this clause become directly because the similar defect exists in him and the author.
Now, whether it is essential clause or whether it is an ancillary clause will be decided by the author of the tender, not by you or me.
When they have acted with a similar defect of the others as to accept, the same year has to be applied to me.
Correct, correct.
Like here, it is not submit the undertaking. The CA has given the certificate. He is not given the undertaking. This document is available on record.
Now we have to see your case, whether there was any infirmity in declaring your technical bid as not responsive. That is the issue first.
Had he
Once you clear that bridge, then we will go to the next. But you're jumping the gun now. You're climbing straight away to the first floor. We're second floor without going to the first floor.
what person? When the clause has been accepted directly in one of the tender, so same year has to be applied. to
Correct,
the
correct. It
other.
has to be applied.
Now the same defect exists. The respondent number 5 he has been allowed. So far as I am concerned, I have
But
been.
that is only with respect to one of the conditions. No, there are the number of conditions there.
First one, but all documents are here, man.
Huh?
All documents are available.
All documents are here, but he needs to take his practice. This is for the first time it has come to this court. And we,
207, the first for the hurdle.
Ah.
It has been issued by the petitioner himself. It should have to be issued by the statutory authority.
Well, the language
Very
does
clear.
not say so, man. That should be kindly see.
Page 170 document is the
Well,
last
the
line.
clause is at page 90, man.
page 170.
Page 170, first round. The
Yes,
last
sir, 170. Well, page 1.
line. 170.
Yes.
A, 2A,
Yes.
the last line. However, it is found that the bidder has not submitted the undertaking duly certified by statutory auditor. Page 207 is the certificate is submitted by the petitioner on his own, self-certified.
Yes. Tell sir.
What does the NIT say?
It has,
What does the NIT
and
say?
it says that
Like, show me the NIT. What does it say?
undertaking has to be given by the bidder and certified by the CA. My undertaking is there, not certified by the CA.
Yes.
He has not given the undertaking, man. He has not given the undertaking at all.
Who has not given the undertaking at all?
Respondent number 5.
Okay, that's a
So,
different issue.
so-
Mr. Counsel.
Therefore,
You see, two wrongs don't make a right.
no, what I'm not on that.
That is what your case is. Your case is, okay, your case is, my document may not be as per the NIT, but since this person's NIT is also, his tender is also not as per the NIT. So, but since he has passed the technical bid stage, I should also pass the technical bid. So basically you're saying, since they have violated the terms and conditions for that person, the same yardstick should apply to you. Correct? No, the question is this. The question is this. We'll have to ask the state to decide whether this clause, that particular clause 2.2.2.8 or whatever, whether it is an essential condition of contract. If it is an essential condition of contract, then it has to be followed strictly. Or if it's an ancillary condition. If it's an ancillary condition, then you should be given also the same yardstick, no doubt about it. But the problem is that whether it is same or not, we do not know. We'll have to see. Let them obtain his
No, what- what- what-
You
what-
see, because if it is given the contract, If depending upon their answer, then we can always cancel the contract even to the private. sector.
Within 1 day, he can complete the entire,
But-
entire tender work. Page 90 ultimately, my lord, only that particular clause 2.2.8 says, my lord, it will have to
Page
by the
90.
page 90. Yes. By the statutory order.
Yes. Undertaking by the bidder
And
certified by the CA. No, he has not given the undertaking. I have given the undertaking not certified by the CA.
page 90, 2.2.8, then here.
Yes.
2.2.8, in case the number 2, Roman 2, in case the annual accounts for the last financial year are not audited and therefore the bidder cannot make it available, the bidder shall make an even undertaking to this effect and the statutory auditor shall certify the same.
I don't comply the second part. He
And what about the other
does
person?
not comply the other one.
Point of the
Yes,
certificate.
that certificate is fine, but his certificate on page 90.
Well, page 293, lottery will see whether it has been
By the CA, not undertaken by the bidder. CA has certified on.
Who is this?
This is in respect of whether the CA has given this undertaking. See, as per the clause, it is the bidder has to give and the CA has to certify. Now, this undertaking is given by the CA, not by the bidder.
292.
93.
I will have the instruction.
Let him get the instructions. We can decide.
There may be some
Let us be maintained. But because the other terms also likewise I have been pointing out, the others are also because of the cost of it take time. Otherwise, any date when you check the matter.
You don't give the work order.
Yes, that's what.
Because it appears that he might have a case.
Yes, sir.
Heard Mr. PJ Cycle, Leonard Kidney found for the petitioner, assisted by Mr. PJ Cycle. The petitioner now established that the petitioner's technical bid was disqualified on the ground that the petitioner's undertaking in terms of work 2.2.2.8 of the NIT.
RFP.
Huh?
RFP.
RFP.
Just for proposal. That I think.
What about that? The petitioner's RFP. To be submitted in support of, in terms of clause 2.2.2.8 of the RFP. No, no. What did I say? What is 2.2.2.8 of the RFP? The other one will be undertaking, the other thing. Had not been certified by the chartered accountant. On the other hand, the respondent number, the tender of the respondent number, not the technical bid of the respondent number five has been declared responsive, even though the respondent number 5 did not submit any undertaking at all. So he also submits that there are other issues which needs determination and which will prove that the petition, that the rejection of the petition's technical bid was arbitrary and needed to be settled. Issue notice turnable in 3 weeks. Mr. B. Gogoi accept notice on behalf of
Respondent
1, 2, and 3. What about CGC? Ms. Again, accept notice on behalf of respondent number 4. What about this NH division PWD? 1, 2, 3, and 5, I think.
Yes, 5.
5 also.
5 is the 5.
1, 2, 3, and 5.
6.
1, 2, 3, and 6. Then Ms. Again for respondent number 4. Petitioner takes care for service of notice upon the respondent number 5. by registered post with AD with hearing within 2 days. Within 2 days. List the matter. On when do you want?
Well, immediately after.
Everything is immediate. We're going to. Huh? Huh?
On Friday. No, sorry, 31st. On first of,
First is holiday.
then the fourth.
On the fourth. Next para. In the interim, status quo as on today shall be made till the next return. Yes, madam, Judge Shakti. Here is instruction. Can you make Brahmaputra board a party?
That's fine.
Yes, you can. Or what you can do is to do it faster. You can withdraw this and file a fresh writ petition. You see, one reason I'm saying this is because it will help all the other cases that have been decided earlier. Not only so you'll be doing a good job for everybody. Because no one has made Brahmaputra board apart. And the problem is to put pressure on the central government uh, for dispersal of your dues. You need the Brahmaputra board. Okay. Okay. Then so you give him the address, everything. Mr. EKJ, let us answer for the petition. Feels that he may be allowed to withdraw the writ petition with liberty to file a fresh so as to make the Brahmaputra board a party respondent in the new writ petition to be filed. So, sir, Ms. D. Jain appears for the Water Resource Department, while Ms. A. Gan appears for the Union of India. You're not there. You're there. Mr. M. Chetty appears for the point number 2. The prayer of the petitioner's counsel is allowed. So, sir, the writ petition is dismissed as withdrawn. Come on, with liberty to file a fresh. Same. Is it required? One case will do, na? We can dispose it off. Or what? If you do it this one also, better, it becomes faster. Then, madam, you'll be looking after Brahmaputra board also, I think. Yes, Ms. DJ. Are you filing affidavit? No.
Yes,
You are filing?
Yes.
Where?
on 26/9.
Okay, this is the one. Okay, this has come. Okay. Huh?
There is no involved.
That he has done the work. But was the work allotted to him?
Yes.
Work was allotted to him. Has the work been done or not? Whether it is done by him or not, that's a different issue. Has the work been done? That is the issue. Huh?
56.
No, you see, because your affidavit is neither here nor there. Your affidavit is that there is no records in the office of the deponent that the petitioner has executed the work. So my question is, Has someone else done the work? Has the work been completed? Maybe not by the petitioner, but has the work been completed? You obtain it, okay, right. No one appears for the petitioner on call. A perusal of the affidavit in opposition filed by the respondent number 4 with regard to the claim for payment of contractual dues by the petitioner shows that work was allotted to the petitioner against the bill value of rupees 9,98,495. However, para 5 of the affidavit in opposition filed by the respondent number 4 states that there is no record in the office of the deponent that the petitioner had executed the aforesaid work. Next para. Ms. D. Jane shall obtain instructions as to whether the work in question that had been allotted to the petitioner has been completed, and as to whether any claim for the completed work for the completed work, comma, if completed, comma, has been made by any person other than the petitioner. This is the matter when seven November.
Last topic of logic directed.
Date.
Last topic of logic directed to bring on record that applicant amount matter. But that we have already filed our affidavit at page 47, we have already mentioned the applicant amount.
So it's admitted.
But applicant amount, 1,25,000.
Huh?
1,25,152.
52.
Page 47, that is it. Our affidavit, we have already applicant that amount. But
Then
it
you
has
pay-
has not paid to pay because of some GST issues. We paid short, which is my instruction.
Okay, we'll direct you to pay. You did not say-
Yes, 1,25,000.
Yes, right. Heard Mr. A.R. Sikdar, learned counsel for the petitioner, and Ms. Yudas, learned government advocate. Government or senior? Learned additional senior government advocate for the state respondent. The petitioner has prayed for payment of its contractual dues amounting to rupees 6,33,83900. Correct?
That is your,
That is dead,
but they have paid for that.
Wait. For the vehicle hire charges in relation to the petitioner's Scorpio number AS 15G-4514. The petitioner's counsel submits that during the proceedings of this case, some payments has been made to the petitioner. And as on date, how much according to you? That amount. And as on date, the petitioner is to be paid an amount of rupees 1,25,15. Next one. Ms. Yudas, the learned counsel for the state respondent submit that in terms of the additional affidavit in opposition filed on behalf of filed by the respondent number 4, the petitioner is to be paid the outstanding balance amount of rupees 125,15. Correct?
Right.
In view of the submission by the, in view of in view of the fact that there is no denial of the fact that the state respondents have to pay to the petitioner rupees 1,25,15. The said amount may be paid to the petitioner within a period of 3 months from the date of receipt of a copy of the file. The requested accordingly.
Right.
Mr. S. Conlon, counsel for the petitioner, submits that the matter has become infructuous. Mr. M. Appears for all the respondents. The petitioner, in view of the submission made by the petitioner's counsel, this petition is dismissed as infructuous. Right. No one appears for the petition on call. Mr. R. Gogoi appears for the APDC. What to do? Does not come.
When the last of the
I know. We are for? It is noticed that no one had appeared for the petitioner on the last 2 days. The same gives rise to an inference that the petitioners are not interested in pursuing the matter. The writ petition is accordingly dismissed for non-prosecution.
Okay.
Yes, Mr. Islam. Oh, okay, you're on this side now. So this para 5 and 6, I think.
Yes.
Correct? Para 5 and 6.
Yeah, that my investigation has not been done.
Has been done. So there is no false documents involved.
Outcome of the investigation is not there. But
No, but as it says here, that as regard the statement made in paragraph 5 the petition, alleged accused, Elepuddin. Elepuddin is the respondent number 7. His name is on the list of students. Correct. So according to this, it appears that he is a student, but investigation not fully complete. They are not.
yes, 2019.
Correct, right. No one appears on behalf of the petition. Mr. M. Chetty appears for respondent number 156, while Mr. S. Islam appears for P. Islam appears for respondent number 7. Next para, you're right. The petitioner's case is that the respondent number 7 no, the response case is that the petitioner had filed a complaint before the OC Bilasi Para, officer in charge of Bilasi Para police station, with a prayer to investigate the forged document, bracket school certificate of the respondent number 7 and take action as per. Though Bilasi Para PS case number 1469/2018 and the section 468/471 IPC had been registered, no effective steps had been taken on the basis of the said FI. Next. The affidavit opposition filed by the respondent number 5 states at para 5 and 6 that the attendance register of the Balir Shah High School for the section 1988-89 showed that the respondent number 7 was one among the 75 students on the list of the. However, the police case, the investigation in the police case has not been completed. What to do?
What is the excess of data for investigation?
Can you get that? You get that? Mr.
Documented is excess.
Mr. M. Tete shall obtain instructions with regard to the status of the investigation in the above police. This is the matter on November. Maybe political motivation. Look, we just can't saw the case just like. At first, this is the first time he's not coming to the.
Maybe more inspection may be required because these there is survive or not. Out of couple of months, the petitioner is unable
Mr. Counselor, what, you see, have you read the affidavit? Have you read the affidavit of the respondent?
No.
Then what more instructions do you do?
Last couple of months, the petitioner is unable.
You please read the affidavit. What does the affidavit say? The respondent's affidavit, what does it say? You've got no idea. And you want instructions. What instructions do you want?
This is the last couple of months, we are unable to connect the.
But have you read the affidavit?
No,
Then read it.
what do you collect? Indeed, affidavit also.
The affidavit says what? The affidavit says that all the rooms have been allotted. There's
Yes.
no room left.
Yes.
What to do? This is of 2019 matter. 5 years have passed. All the rooms are gone. Now, you see, if you are going to be allotted a room,
Yes.
even supposing, imagine that you have got, assuming that you have got a right, the person who has to be now evicted, supposing you get a right, won't he have to be made a party?
Already we are mentioning your petitions, my lord, they are procedures of the constructed, we are completed, but the union already, they are allotted me the rooms, but unfortunately the chairman is not.
The rooms are all allotted, all occupied now. If they are all occupied, now what to do? Yes.
You have to put some state to run.
He's been given. Oh, very good.
I mean, informed, I have not been, I think. Okay, they are telling that, obviously they are become something like that, he will, which way it is.
Can you give that in writing to us?
No, bro, I am asking him to give me that something so that I can also take it on.
Ah.
It's informally I have done. That he is telling because this party are not expected.
When did you speak to your client last?
Last year, the Tiketa conductor typically informed me about for last couple of months, open, for the last couple of months.
Informed you what? Informed you what?
So last couple of months, he's unable to connect the, this mark. So that's why we are between the, whether it's survive or not. So need more time. Next, definitely will be good.
Okay, okay, Mr. RK,
Not-
huh?
Anything, not.
RK Nath, Parent counsel for the petitioner submits that he has not been able to contact the petitioner for some time. Petitioner for some time and needs one last chance to to try and communicate with the petition. Mr.
Alam, yeah.
A. Alam appears for the
and four.
respondent 2, 3, and 4 and submits that he needs some time to obtain instructions in the matter. List the matter on. You get information by the. Yeah, list the matter on so to enable the council to obtain instructions as to whether the rate petition has become infructuous or not. This also appears to be infructuous.
These are for remission, my lord.
Huh?
Remission, they are claiming remission.
No, at 24 has been, 24 has been, I think already dismissed as infructuous. 24. No? I said no. No, 26. No, you see, this matter pertains to, okay, this for remission.
Remission.
But then the hut has been, the settlement period has been over.
Yes, yes. Therefore only they are claiming. As per for rule 14(9), my lord.
So why, have you taken a decision?
No, my. They have to approach the government, my lord.
That's not approach. Under what provision?
Rule 49 of Assam Panchayat Financial Rule.
For remission?
For remission, they can pray for, my lord. It's up to the government to
Take a decision on. But they have not gone there.
They have not taken.
I don't know where have they gone.
I think that this one application is there, my lord.
They have already approached, according to them, they've already approached the government.
My lord. But this is not matter for
It's not here. Right, no one appears for the petition on file. The petitioner's case is that his application for remission of the settled value in respect of settlement of the Mandya cattle market for the period up to 30/06/2020 has not been decided by the state respondent still. In the interest of justice, place the matter again on.
Letter may be transferred for the.
You have admitted to 21 lakh. Huh? Not your application, no? Yes, stop the scheme matter. Now there is. I think there is an admission by one of your. Okay, right. On the paper, a judgment made on behalf of the petition council leaves the matter after the petition. Yes, anything you want to say?
I will be telling the application for
Okay, Mr.
I'm
Okay, right. We can have the council appearing on behalf of Mr. P. Deka, PGC, affidavit on behalf of the respondents number 3 and 4 will be filed during the process. On behalf of point number 3. This is the matter after. Yes. Let us dispose of Jal Shakti is there. Jal Shakti is not, this is not a Jal Shakti case.
Next, marketing.
Has not been made party. This Jal Shakti and that Brahmaputra board. Mr. Council, I'll just tell you one. There are number of writ petitions which have been disposed of by a common order sometime in 2022. And all those cases now are lying in contempt. There are contempt cases filed on the basis of those cases. So, and that is why now to realize the orders, to realize the money on the basis of those orders issued, we need the Union of India as a party because they are supplying 90% of the money of the fund. If state share is 10%, central share is 90%. So state government says that we have already paid 10%. Central government has not paid 90%, and they say that once it is verified by the authorities, it will be sanctioned. Now, for that to happen, now they are saying the central government council is saying Brahmaputra board has to be made a party because they will approve huh? Yes, they are the monitoring agency. They will approve the bills, and on the basis of that, when the central government will issue the fund. So that is why, since the Jal Shakti ministry is not a party, and since the Brahmaputra board is not a party, you make them parties here. Then it becomes easier. And I can pass the order, but then when it's going to be implemented, state or government will say, we have paid our 10%. 90% you go claim it from the center, you'll have to file another writ petition. Huh? You have to file amendment. Okay. But you implead Jal Shakti and Brahmaputra board. Right. On the prayer of Mr. D.K. Jain, the passes for the petitioner, the matter stands adjourned for hearing.
It's the time for the petitioner. There is a, we have received a copy of the affidavit. I think it is not an on record from the whole India. This is respondent number 6. Right. So we would like to respond to this. There is a remote operating field. Who has filed it? We have no knowledge, but no notice has been issued regarding the application for vacating of the order. A notice may be issued. In that case, also we like.
Under 2263 or what? No.
So they are not still moved it.
Okay. Good.
It's the first step to it.
Okay.
It is not. It has been.
Okay. Anyway,
It has to be moved first. But you not given the order.
okay. No, it's not.
The last order.
Ah.
50. Page 18 of that.
Yes. Yes.
SB 19.
Yes.
Considering the facts and circumstances and also being afraid that the work order is yet to be issued. It is provided that bill is discernible no final work order in because it was. The present order being passed expiring for the respondent number 3 and without inspection taken by the respondent would be considered or to take that to be the traditional.
So now since this has come for the first time, I think we'll have to issue notice on this.
As far as the getting of the very important. So reasons which have been explained in the it's a project of national import. And we have finalized it in the work of the PET because of the interim order now we are stuck. They wrote to petition the Supreme Court. The recent judgment in 22 SCC, page 1 there is no all these everything. That means it is just last portion you will see. Paragraph 26.
Yes,
The word of caution also to continue that any contract of public service should not be interfered with lightly, and in any case, there should not be any interim order revealing the entire process of the services meant for larger public use. The grant of implementation by the learned single bench of the High Court has no one except the contractor who lost the contract with and has only was lost in case with no corresponding gain to it.
okay.
And this is a court says input assess that such cases High Court should not interfere. Except again, if this is late now. We'll have to retain the deed, which will be making us liable for express defeat. I'm not opening my cards. And here that issue is very tricky. Whether I was rightly or wrongly thrown out of the my technical it was rejected. And there is only one remaining symbol. And there is a huge price difference between my offer and their offer. Whether those process on the basis of which I was considered non-responsive. Whether those are mandatory conditions or directly number one, and whether at all there is any violation. So the Lordship will have to examine. And they, so far as Coal India is concerned, where my learned signal plant is empty, they have not found the beginning. You have find the king of all. You are entirely right about.
Yeah, fine.
Because filed by the private respondent. No. Filed by the Coal
Corner
India,
number 6.
we have received the vacating
No,
petition filed by the
respondent
private respondent.
No, filed by.
Notice it told me, we are the parties effect.
Has been filed by.
Subsidy. In any case, Lordship, I would like to respond to this also as well as to the eligibility also.
Only one thing. The problem is the Supreme Court has in this judgment.
This is not a project of that nature.
Not that.
Now, it is extraction of coal. Yes, this is as if not as release stopped or a road construction is stopped. It's not of that. This is of national importance because coal caters to steel and cement industry, all variant. So
Why do you come at the last moment if it's such natural
And-
importance?
on the other day, it was not us who stopped time. So that there the matter was adjourned till today. They have taken time on the last occasion. Then the private. Now there's a segregation, but they all responded.
You see, there is a Supreme Court order, and more than all of you are, we are more scared of the order because we are they are there looking at us. Are we obeying their orders or not? So I am under the, I am under the scanner.
Not that is judgment by judge, but the normal procedure, because if they get the
Only
application-
problem is that this has come for the first time today. So,
Because of the urgency of the matter and
So it had come up.
But- it has come, no, I had not come.
I had
No, it has come for the first time. First time. I is for the first time.
notice may be issued, Lord.
We'll fix it straight after the opening.
Immediately on your.
Immediately on reopening, we'll take up.
if not anything else.
No difficulty.
Huh?
Oh, it cannot be.
For the entire matter.
If not, the entire matter, because hearing the interim, like interlocutory application will be same as hearing the whole.
Correct, it'll amount to the
Yes,
same
that
thing.
is why.
It'll amount to the same thing.
Any day in the first week of November.
No.
Immediately. If they, if I have full right to make my submission. I have full right to
Correct,
make my
correct,
submission,
correct.
number one. And number two, lot of cases are already fixed during the.
Very lot, a lot.
That is
lot.
why I am also totally, because I have to seek adjournment on that day. That accommodation may be given, then I have no objection.
No, more than that. You see the other cases out here, there is a caveat. There is a problem. There is,
So this judgment is not applicable to this case. This case. And lordship, if when this it is whole India can give the undertaking before this honorable court, then they will not take 6 months to settle the tender process. I'll be more than happy because it will consume more than 1 year to settle this. Not through litigation, because they own procedure.
whole. Oh, it's a all India basis.
This is regarding Margherita lordship. It will take about 1 year to 1.5 years for settlement of this project.
It will take 1 year if the.
No, not because of litigation. Not because
No,
of
I
litigation,
don't,
because it's not that they have to go through a lot of procedures.
finalize we can.
Anyway, what we'll do is, in the meantime, first of all, pleadings have to be complete. Your pleadings are complete. Okay. So any other respondent is there? So you have got nothing to do. You have finished. That's point number 6. Anybody else is there? So now we have got only Mr. D. Saikia to submit their reply, written objection to this IA,
As well as.
as well as reply to the affidavit filed by the respondent number 6. That's all.
And whether they would like to file.
Are you going to file a affidavit in opposition? Huh? Ah.
Or if they have also filed, so we
They have filed.
respond to.
So only
Both.
2. So one is your written objection and in the IA and with regard to the
Both the affidavits.
both the
will file
affidavit.
counter.
Okay, right. Okay, I'll just write down. You'll just tell me. Now, but what date should we fix?
Immediately on reopening at the interview.
Okay. Try to come to a
Let it be on 4th of November. It's a Monday. All cases are fixed, Lord. That's why
no, I agree. Even I have got a lot of cases.
5th of November, it's a Tuesday. I do not want to take adjournment on that day. Lord.
Let us see. What does Mr. Amit say? Huh? Not 4th. You don't want 4th of November? Huh?
5th or 7th, Lord, whatever.
Oh, 7th, oh, no. We have got Mr. P.K. Goswami and Mr. B.C. Das and all already. That is. Okay, okay.
Yes, yes.
5th, okay, right. In the IA, you're right, huh? Heard Mr. M. that Amit, the senior counsel for the applicant, who is the respondent number 5 in the writ petition. This application is for vacation slash cancellation slash modification of the impugned interim order dated 6/9/20 passed in the main distribution. The issue notice returnable in 3 weeks. Mr. Who accept with S. Data appears for the appears for the
Writ petition.
so to this Mr. D. Saikia appears for the writ petition and submits that he will file written objection within
2 weeks.
within 2 weeks.
Immediate reopening will submit.
Within 2 weeks. Suppose that he will submit the written objection on or before 21,
On of
21 10,
20 the reopening later
21 10,
26.
26 10,
Yes.
25th, 25th 10, 25 10,
Before
20,
25th.
25 on or before 25 10 2024. So, sir, the applicant may submit any reply to the same if required. List the matter. Now, on the prayer of the parties, list the matter on 5/11. Then in the main case, you write, before that you write, Mr. I. Chaudhary, Learned Counsel for the respondent number 3 and 4 in the main writ petition submits that he will not be filing any affidavit in the IA. That, and he'll be relying on the application, on the pleading submitted by the respondent number, pleading submitted by the applicant. Okay, then next. Then in the main case, you write, heard Mr. G. Saikya, learned senior counsel for the petitioner. Also heard Mr. M. Z. Ahmed for the learned senior counsel for the respondent number 5 and Mr. I. Chaudhary for respondent number 3 and 4. Mr. R. M. Deka appear for respondent number 6. That's all. Mr. G. Saikya submit that he will be filing, that he needs time to file affidavit in reply to the affidavit submitted by the respondent number 5 and 6. The same should be filed on or before 21/10/2020, 25/10/2024. So stop. Mr. I. Chaudhary, learned senior counsel for the respondent number 3 and 4 submits that he will not be filing any affidavit and he will rely upon the affidavit submitted by the respondent number 5. And then you write, list the matter on 5/11. And in the meantime, the respondent may also file any additional affidavit that they may want to file. An endeavor shall be made to dispose of the matter on interim order to continue till the next.
Highly operate. Can it be on proposed?
We can, if you want, we can list it at 2 o'clock better. If you want at 2 o'clock, we cannot put it over the thing. Let it come as per the, or that is a Thursday,
Tuesday.
Tuesday. It won't be a problem. I think. It can be a lot. You mention it,
If they are in a hurry. Yeah.
Okay. I'll say Jal Shakti, here was it. Okay, right. Third, Mr. DKJ. I learned counsel for the applicant. Slash lead petitioner to praise that the Ministry of Jal Shakti where is your prayer? Oh no, huh? What is it? Item number? 3136. No, what have you given me? It's three. Acha, okay. Who submits that the Ministry of Jal Shakti. Department of Water Resources? Yes. Is that the correct name? It's not correct. It's not correct. It's not correct. What is the correct?
Only Department of Water Resources.
Yes, the Ministry of Jal Shakti. River rejuvenation. That's all.
Yes.
River rejuvenation. Come on. New Delhi. One. But it should be secretary to the government of India something. Union of the Ministry of Jal Shakti.
Correct.
You just say Union of India. Union of India. Represented by the commissioner. Commissioner? Cannot be commissioner. There's no commissioner. There is secretary. Huh? Everything will be theoretically be wrong. Cannot be corrected like this. Yeah, I'll tell you what you do. You file a fresh application. Because you see that earlier we used to correct it by hand. That is not allowed anymore. It does not get uploaded in the CISF portal. So you give him the correct address. Give him the correct address. Give him the Brahmaputra board also. So let him do the correct. It is not correct. Making a commissioner, department, okay, right, Mr. DKJ, the counsel for the applicant, says that maybe you have to withdraw the application with liberty to file a claim. Praise the Lord. Huh? The, that, uh, the I is accordingly dismissed as withdrawn, come up with liberty as well. Then you please take the correct thing from. Then in the main case you write, Mr. DKJ appears for the petitioner while his DJ appears for any relation
No, Your Lordship.
and DJ appears for the water resource department. Mr. M. Chetty appears for the point number one. This is the matter after the case. So you file it. We'll allow, but just make it correct. Just take it from his office.
On 18/10/2023 law is allowed for the matter is pertaining to industrial matter. So, they are not.
LCR not received yes. Okay, right. Mr. K. Kalita appears on behalf of. Huh? Your name is not here in the file. H. Kalita is there. Have you filed Vagalatama? Let me see. That's what Mr. K. Kalita appears on behalf of Mr. A. Sharma, Senate Counsel for the petition. Mr.
M. Islam on behalf of Ms.
M. Burman. Mr.
M. Islam.
M. Islam appears on behalf of Mr. M. Burman, Senate Counsel for the respondent. Registry to send a reminder for the LCR from the Learned Labor Court Dibrugarh in reference case number 01/2008. This is the matter after 4 weeks.
Of the reference is case number 1 of 2008.
This case number 1
of 2008 in reference case number 6 of 2000.
This case number 1 of 2008 in
Reference case number 6 of 2000.
earlier order is wrong that we should have made this order. And What is the reference case number?
4 of 2006. Case 1.
4 of 2006, reference case.
2016. 4 of 2006.
Okay, miss case number is?
It is 1 of 2000.
Miss case number 1 of 2018, arising out of reference case number 4 of 2000. Okay. Probably that's why it has not come. In the earlier order, it has been said 1 of 2008. Correct. Correct. No one appears for the petition on file. Mr. S. Datta appears for the PNR. No, come on, who submits? He submits that this petition has become infructuous in view of the fact that the settlement of the Balbala weekly market was for a period from was for a period for a period from 1/7/22 to 30/06/22. In view of the submission made by the counsel for the PNRD, the writ petition is dismissed as infructuous.
Hello.
No, AD, what to do?
We'll press.
Yes, sir. Okay, right. As office note indicates that there has been no return of AD card or unserved notice from the sole respondent. Petitioner to take fresh steps for service of notice upon the respondent. Steps to be taken within 2 days. This is the matter after full.
Seeking time. The scope of the contempt matter, the parent order whereby when the contempt was brought is under challenge. Inside the script.
Okay. Mr. D. Roy Leonard, counsel for the respondent number 1, submits that the parent order is under challenge in WA number WA 468/2020. And the same is still pending before the division. Accordingly, this is matter after 6 weeks. Hold it. File. Yes, please.
I am interviewing for option number 1 and 3. But it subsequently comes to the direction of the honorable court, sir. Page 10,
Page 10.
page 10. Para number 5. Para number 4 and 5.
Number 4 and 5, yes.
4. The court has given NCS consideration to the matter and legal of the opinion that the interest of justice will be made. If there is a direction to the responsibility to make necessary verification and upon verification, if it is found that the petitioner is entitled to the amount claimed or any part thereof is to be paid to the petitioner in a time frame. But then verified authority is put therefore of the directly the number of transfer the purpose of it. I mean not to
3
verify.
months time.
Plus, in fact, paragraph 6, 23, paragraph 6. This court order director food civil supplies and consumer affairs Assam to do the needful so that the amount be released. Plus, after the honorable court order, they have verified and they found that amount is protected. They have the director is now the commissioner of civil supply. He has been dedicated. He has passed an he has given communication to the secretary because of the reasons stated there. The petitioner is
Where?
kindly have a look at the 7th of June 2024. Pursuant to honorable court order, I have the honor to inform you that both the petition is connected with order dated 22/11/23
as ordered the 24/11/23, passed with application number 6696 of 23 and 6724/23. So we are concerned with 6724/23 here. That is
6724.
6724 here. Respectively have been perused and examined by the undersigned on perusal of the records of following facts of it derived. Vedanti Printer Sweater, he has if relevant portion logic file take the logic to that much. Paragraph number 6. On receiving the certificate dated 4/12/2023 in connection with the order dated 22/11/23, passing application number 6696 of 23, and another petition on the same date, that is 4/12/23, in connection with the order dated 24/11/23, passing application number 6724 of 23. The matter regarding pending liability against his past and father, as per joint verification with the deputy director in charge so the matter of claiming of surplus bill amount, that is 15,54,000 and 30,99,441 for the same work done by the firm. It is observed that the petitioner has been paid. Basically, sisters will not be entitled for the 13,99,441. As per application dated 4/12/2023 in connection with the order dated 24/11/2023, passed in WPC number 6724 of 2023. There is also to be mentioned that here the budget allocation, the 15 lakh rupees that has been already paid to the respect of the other. There are two orders, 15 lakhs has been already
No,
paid.
what? Why is he not? Why is he not entitled?
Yes.
The reason.
Plus, paragraph number 1. MS Bhagwati Influence taken as sample for selected for the work of painting of registered series 2020-21 by office of the Deputy Commissioner sample by order number 29/2020. It seems that the work of painting of registered is sample district was out of the government instruction by number 12, dated 25/2020. Further, the proposal submitted by Samprop paying the bill amount of 13,99,441 was returned by the Office of the Commissioner Supply on the ground that the printed page had variations in the format of the form of ration card number and member ID available in the page number 7 and 8 of the newly printed ration card. The same has been communicated by paper number 2. Plus, whatever the work they have done, that was not
The format.
and for the they have to print up. Plus, they were given two. One is writing. For writing, they have already the first of the system. And the printing, there is variation. That is why they have. And one of the second communication I have also given the first. 2nd of July 2021.
Yes.
The director has written to the commissioner, deputy commissioner, Dr. Maninda, as regards payment of 2023 bill and the newly printed ration card. So there he has informed the commissioner, the deputy commissioner, with reference to the subject cited by the owner to
Same thing.
So what I would like to point out, this communication has been marked to the operator of the communication of 2nd of July 2020. The third stage, it is a part. It is that is the but that if there is
Separate orders have been passed.
Huh?
That separate orders have been passed by the authority. And that found has been that work in this case. And subsequently the project work has been done. That the bill is completed. And that time also that no section is by the authority. And subsequently after submission of bill, it has been sanctioned me. And thereafter that bill was not released. Subsequently filed good. That's 69626.
No,
And-
it's the constant. Come page 10. Para 4. Yes, please read. Please read loudly.
Court has given consideration to the matter of the opinion that needed to be met if there is study from authority to make such meeting. Upon verification, it is found that exceeded accepted amount paid or any part thereof, they may be paid specifically in time.
So they are supposed to make a verification. It is not a question of admitted amount. So they have made a verification in the sense that they're not entitled. Now you have to challenge this order.
Right, that's what
No, that's not denied, but they are saying that we are not going to pay you because you have not done it as per the required design that they have. That is what they basically say. No problem. This is a contempt. The problem is this is a contempt. This is not a writ petition. In a contempt, only thing we have got to see is whether the direction passed in the writ petition has been complied with or not. According to them, they have complied with it because they have had a verification and they said they are basically saying that since there was a variation in the format of the printed card, you are not entitled to anything. It's like this. Supposing I ask you to make me this and you give me this. Now, why should I pay you for this? I didn't ask you for this. If I ask you to make a shirt for me, and if you give me baby size, why should I pay you? It's like that. That is what they're saying. So you have to either challenge this if you want.
Yes, communication regarding.
We are giving to you now. There's nothing now what to do. What do you think can be done? That is what they're going to say. They are basically saying that we have complied with the order. Court has said make a verification. Now well at pay if they're entitled. They are saying that they have made a verification and that they're not entitled. Whether it is right or wrong, that we cannot decide in a contempt case. The only thing is we have got to see whether they have complied with. Now the thing is that they are saying that yes, you have done the work, but not as per the specification. So you're not entitled to. That's what they're saying. Please, can we take that up in a contempt? That is the problem.
My there are two content methods. That both methods will be looked at.
Why? How does it make a difference? Whether they're listed together or separately, how does it make a difference? How does it make a difference? We close this with you, take a copy of this, you challenge it. It's very simple. Like I gave you the example. What is to be done? What instruction? You have got to tell it. It's okay. You will give you this, you take a photocopy or you take a with your phone, you take a picture, you print it out. Do you have an extra copy?
I have a copy.
Can you do it?
The concept because there are two different things.
The other content payment section and what is remain? So why should we fix it together? How does it make
But the same other thing that we entitled for ticket. Of course.
Anyway, that's a admitted amount that he can be a challenge.
I have no insight
Right.
regarding the
No, huh?
that amount.
No, that is a different issue. I'm talking about this case now. We'll take one case at a time. Heard, mister? Yes. Heard, mister?
Yes, enough.
That's in our learned counsel for the petitioner. Also heard Mr. Srinath, hearing for the response number 1 and 3. The petitioner's case is that the order dated 22/11/23 passed in WPC 6696/2020. Passed in,
24/11/23.
when is that?
The page for page by
Order dated 22/11/23, huh? Past
24, 11,
20,
4, 11.
no, it is 22.
Page number 9.
It is 22. WPC 6696.
This is this is
Acha. Okay, we'll finish that. Submit that. The Order dated 22/11/23. These are two contempt petitions though. Okay. 22/6696/23 past it WPC. No. 22/11/23 past it WPC 6696 has not been complied. On the other hand, Mr. Dina, learned counsel for the respondent number
But one and
1 and 3 submit that the order passed in WPC 6696/2023 has been complied. Next up. I have heard the counsel for the matter pertains to the petitioner seeking a direction to be issued to the respondent authority to release the amount of the petitioner's case in WPC 6696/2020 was for a direction to be issued to the respondent authority to release rupees 15,54,935, including the GST payable to the petitioner firm on account of putting beneficiary details on the ration card by manual writing under the NFSA project under Kamrup district. This court, this court, by order dated 22/11/23, disposed of WPC 6696/2020 by directing the Deputy Commissioner Kamrup Amingaon to verify as to the entitlement of the petitioner as claimed and upon making necessary verification, if it was found that the petitioner was entitled to the amount to claim or any part thereof, the court directed the whatever I said. Amount they claimed or any part thereof, the said amount was to be released to the petitioner. One thing, Mr. Dinath, other judge has been complied with. In this regard, he has relied upon letter number TS to stop 317/2023/48 dated 7/6/2024 issued by the Commissioner Food and Food, Civil Supplies and Consumer Affairs and Legal Metrology, Assam, and the Assam, which is to the effect that the petitioner in WPC 6696/2020 is entitled to payment of rupees 15,54,935. Mr. Dean had submit that the commissioner, FCS and CA and LM was the earlier deputy commissioner,
the directive,
was earlier the director of
paragraph number 6 of the paragraph 6 of the
was earlier the director of FCS and CA Assam. And as such, the directive issued to the respondent have been complied. The respondents in the writ petition has been complied. Then before the secretary, just put one more thing. He further submits that that this court had directed the director, FCS and CA staff also to do the needful so that the said amount could be released to the petitioner upon making necessary verification. Necessary verification. Then that's the thing. Then we come back. I have further learned. Para 4, 5, 6, 7 of the order dated 22/11/23 passed in WPC 6696/2020. States as follows. Next para. The letter number DS was of 317/2023/48 dated 7/6/2024 issued by the Commissioner, FCS and CA and LM, Assam, who was the earlier director, has admitted to the fact that the state respondent have an outstanding liability of rupees 15,54,935 payable to the petition. Correct. And they have not paid this amount.
It is already
I already paid.
fine, sir.
Acha, one thing you've got right. Mr. Dina don't submit that the set amount of 15 lakhs has been paid.
Last section 23 section of FOC for the paid amount is yet to be. Subsequently, they have received and it is.
Paid, huh? Paid, huh? Next paragraph. In view of the submission made by the, no, next paragraph, the letter dated 27/6/2020 is made a part of the issued by the commissioner, FTS, CA and LM, made a part of the report and marked as the next. In view of the above letter dated 7/6/2020, this court is of the view that the order dated 22/11/2023 passed it as a PC 6696 has been complied. According the contempt petition standing. Okay. Then what about the other case? There's one more case is there. Sir. Oh, so the one
But the policy is so concept first like it's better.
at 297.
And other one is 290. Possibly documents pass the audit.
No, this is 297. I passed the order in 297.
But then the copy this is just here 297 first, but it's like
No, out here it shows 15 lakhs.
if it's for the that it's 35 for that.
No, wait, 15 lakhs is for what?
15 tax is for WPC number 6696/2020.
Huh? 6696, that's what. So he has been paid 15 lakhs.
Yes.
Sir.
And I said that budget that this is for the 6724/2020 for the other one.
That other contempt is not
It
here.
is not this, it's not.
It's only for 6696.
6696
So 15 lakhs, so it has been paid.
it is
And the other one is not there. Yes, then. 9, 8. Okay. In treatment of
Contact number 4,
okay, heard, Mr.
SC Prakash.
S.B. Prasad in the IA, huh? Yeah, two IA. That is S.B. Prasad, learner counsel for the applicant to submit that what has happened to this Ashim Kumar Bhattacharya? He's retired or transferred or what?
He's there. Acceptable given to him on the last full contract. Last and on. It is the current.
To submit that. Sri Anand Malhotra IAS subdivision SDO some district election officer from a Jonai subdivision. Jonai. Yamaji district Assam 787060 should be included as respondent number 2. Just give me that order. In view of the order dated 11/9/2024 past date. Contempt case number 508 of 2020. 509 of 2020. Huh? Then Mr. Tina, then it passes for the state for the respondent. For the respondent number 1.
For the one and two earlier. Now,
No, there's no 1 and 2.
earlier one and two, there are two. In the main case, the
Huh?
base of our, I think, is for six.
There's only Acha, 1 and 2. Then Mr. Counsel, why you pray for
You
replacement of respondent number 2?
want to replace the earlier.
Acha. So what about it? No, before that. Start from the beginning. As respondent number 2, in place of the existing respondent number 2. No. In view of the fact that the present respondent number 2 has been transferred out. Has been the earlier one has been transferred or not? Has been transferred out.
In March to
Right. Mr. Dinar, counsel for the respondent number 1 and 2 submit that is but not taken to the state accordingly. So, is considered as respondent number 2 by substituting the earlier respondent number. Applicant shall submit a revised cause list to the registry within a week. Within 2 days. I is accordingly allowed and let me make it the main case. That is in 509. No? 509, right? In view of the order dated C. So, 24. So is impleted as a foreign number. It will be repeated as a foreign number 2 and substitute the existing respondent number. Issue notice to the newly impleted respondent number 2. Petitioner will take steps for service of notice upon the respondent number 2 by a registered post with AD within 2 days. This is the matter of the following. Okay. Then in the other case, filed in that other IA, that is 3403. Same order, except this will be, date petition will be 508.
Method is here order. Six number. So,
We take steps first. Huh? We have two of them. We both 3 or give a date. November. Finish.